Good morning, everyone. Could I please ask you to take your seats? Yes, good morning again. We'll resume the hearing of the applications lodged by Dunedin City Council for the proposed Smooth Hill landfill, and this morning we're carrying on hearing from submitters. But just before we commence properly, we're going to have a health and safety briefing since we have some new people in the room this morning.
Good morning, everybody. In the case of fire, if the alarm system sounds, please evacuate the building using the fire exits. There are doors at this end of the room and also behind you at the front of the room. Please leave across the road at the Herrick Street car park, and do not enter the building until the warden has given the all clear. In the event of an earthquake, please stay in the building, move away from any equipment and furniture, and take shelter under solid furniture. Toilets are located at the front of the building. Turn right and follow the corridor downwards. And smoking is not allowed in the building. The designated smoking area is outside at the main entrance on Herrick Street. Thank you.
Thank you for that. From the reporting officers, anything for us this morning? And from the applicant?
Just one procedural update. Kia ora koutou, and good morning, Commissioners and everybody. Just to advise you, you may well already be aware, but we filed yesterday the list of answers from the experts, so that should be with you now, hopefully. Oh, good. Yes, thank you.
We've received that. Thank you very much for that. Now, our first submitter this morning is Shane Turner, who apparently can't appear in person and may or may not be on Zoom.
Yes.
Mr. Turner, good morning. Can you hear us?
Yes, I can. Can you hear me okay?
We can hear you and see you, so please proceed. Just for your benefit and all the other people we'll hear from today, we've read the original submissions that were lodged. Thank you very much for providing those. You don't need to reread those out to us, but you're of course very welcome to highlight any key points that you wish to draw to our attention, and then we'll see if we have questions for you.
Certainly. Good morning, everyone, and good morning, Commissioners. Yes, my name is Shane Turner, and my wife, Sasha, and our two boys, Malachi and Zach, who are aged 9 and 6, live on Big Stone Road, approximately 4.6 kilometres from the proposed landfill site entrance. Just some background, I grew up in a small town in Southland on a farm, and I always wanted to give my children a similar upbringing to the childhood that I experienced. My wife and I purchased the property in Big Stone Road in 2015, and we moved out from our Dunedin city home in 2016. My two boys attend Big Rock School in Brighton, and as a family, we do love our home, we love our property, we love our community, and we love our surrounding environment. And this includes, but not limited to, things such as family bike rides in the neighbouring forestry blocks, visits to the creek that runs through this forestry block, which is a tributary to Tokyo Creek, to explore and search for freshwater crayfish, also known as yabbies. Regularly, we visit the beach that runs parallel to Torrey-Mouth Road. We walk our dog, we play and swim in the ocean. And during summer, Brighton is flooded with visitors. Young children would play in the estuary, with kids and adults of all ages enjoying the waves. Brighton is a playground for families, and some would say it is Dunedin's best kept secret. On a good day, there are hundreds upon hundreds of people enjoying all the best things that this idyllic stretch of coastline has to offer. When we found out about the proposed Smooth Hill landfill, it was from one of our neighbours. My initial response was there must be some mistake. Surely that can't be happening. We live less than 5 kilometres from the proposed site, and we were hearing from our neighbour that a landfill was being planned just up the road. Hearing about this proposed landfill without any communication from the council was very stressful. I contacted the council in early 2020 to try and get more information, and I was told by a staff member that I wasn't considered an affected resident. This seemed absurd to me. How could I not be an affected resident? And so began this journey, which I don't need to elaborate on, only that the way the DCC has handled this is nothing short of, well, criminal. The complete lack of consultation has shown me and the wider community that the DCC doesn't care less about the impact that this proposed landfill has and will cause. The mere fact that they have dismissed me, my neighbours and residents of Brighton suggests total arrogance and disregard for those that live in the area. I've been a ratepayer in this city for 14 years, and 6 of which we have lived in Brighton. I'm absolutely disgusted that the council couldn't get off their backsides and show just the smallest amount of respect for our community. Let's talk about this community. A school of 100 kids and growing, a childcare centre of 30 children and growing, a population of 1,600 residents and growing, a surf club, a bowls club, a gala that attracts over 10,000 visitors in January each year. I've mentioned the beaches. Most weekends you'll see horse floats gathering at car parks with horses and riders enjoying the beach. On Big Stone Road where I live, you will see the mountain bikers riding up into the forest blocks, returning with dirt on their bikes and smiles on their faces. Brighton has its own cafe, a dairy with the best ice creams in Dunedin. We have a club for locals and visitors to meet and enjoy a beverage, and on the last Sunday of each month, a jam session that attracts people from all across Dunedin to come and play their instruments and sing their songs. On Dunedin Tourism's very own website, DunedinNZ.com, Brighton is described, and I quote, "On the coast, a few minutes south of Dunedin, Brighton and the nearby settlements of Waldronville, Westwood, Ocean View are well-kept local secrets. This idyllic stretch of coastline takes you all the way down to Torrymouth and makes a great driving route with plenty of stops for beach walks, picnics, swims and fish and chips." I mean, there is no argument Brighton is a very special place. It's filled with families and kids and people who love the outdoors. It is a place that my family and I had planned to spend our lives. Our children would grow up here. We would enjoy our property and the environment well into our retirement. If this landfill was to go ahead, there is no argument it would be detrimental to me, my family, the residents that surround the Smooth Hill, and the wider Brighton community. It will be detrimental in the sense that it will impact the environment, it will impact our lifestyle, it will impact the image and brand of Brighton, and it will impact the value of our property. The loss of value in our property will be significant. It will put at risk the beautiful environment and the community's efforts to enhance and look after the wildlife. What I struggle to understand is the logic of this proposed landfill. It just doesn't make any sense. Why would a council go to war with a community over something that doesn't need to happen? Why are we even here today? There are other options, yet the council seems determined to pursue this location. Why? Why would they not use their time spending ratepayers' money who pay their wages to explore alternatives? Why upset a community when they don't have to? Why waste money, and the council seems very good at doing that, when they could be spending this time investigating and coming up with a solution that the people of Dunedin can support? It just doesn't make sense. Yet here we are, a small group of people fighting for our livelihoods when we just shouldn't have to. This decision will leave a legacy for this council forever, and the council has an opportunity to do what's right. And I just implore that common sense will prevail. Thank you.
Thank you, Mr. Turner. I'll see if we have any questions for you. Jan, any questions?
Thank you, Mr. Turner. I haven't got any questions. I completely understand all of your points. Thank you.
And Roz.
Morena, Mr. Turner. Thank you very much. Acknowledge the time that you've taken today to present to us, and it's clear the passion that you have for your community and your family's experience in the subject area. So thank you very much for setting all of that out for us. I was wondering, so I've got a picture of the general concerns around the proposal. Is there any specific effect that concerns you the most?
Oh, look, I think it's there's a number of general issues here, but certainly the location is one, but the detrimental effect that it will have on our environment, it'll have on the landscape of Brighton, it'll have on the image and brand of Brighton, but just the ongoing concern that I have around whether or not the council can pursue with this large investment in an area that really isn't suitable.
Okay, and I don't know whether you've been able to tune into any of the hearing proceedings this week, Have you been able to listen to any of the experts' views or responses to your submission at all?
I'm trying to catch up on that, but it's been difficult when I'm
Yeah.
working full-time and travelling
Sure.
at the moment.
Yeah, okay. Well, thank you so much for that. Appreciate your time. Thank you.
Thank you for hearing me.
So, Mr. Turner, you said that you live 5 kilometres from the site. Is that 5 k's from the intersection of McLaren Gully Road and Big Stone Road?
No, 4.6 kilometres from the entrance to the landfill to our driveway.
So how many k's would you be from Brighton Beach Township, do you reckon?
From the Brighton Township, roughly 2.5 kilometres.
Okay,
Sorry, I beg your pardon, closer to 4 kilometres.
okay. I've just got a Google Maps image on my laptop, so it just helps me to see whereabouts you live. So that's
Yeah,
good.
certainly.
But other than that, thank you very much for your submission. Endorse the views of my colleagues. Your points have been made clearly, so we don't need to clarify anything with you in that regard. Thank you.
Thank you for hearing me.
You're welcome. So, Ms. Irving, I think the next submitters come under your control. So, good morning and welcome.
Yes, yes, thank you, sir. Just, I've got some matters I'll cover just in relation to legal submissions, but before I do that, I'd just like to invite Mr. Kahui to give a karakia to open the case on behalf of the submitter group.
Sure.
Kia ora koutou. Yes, I want to open up the doors and at the end of the day, I want to close the doors and leave all the good in the phone. Rōranga te rama, tēnā koutou, tēnā koutou. Me mihi ki torongo roa, nāna ne ngā mea koutou. Me mihi ki ngā iwi, ngā tahu. Ma te mamui, me waitaha. Me mihi ki a koutou, kia ora. Me mihi ki a koe, me mihi ki a koutou. Ko te kura, ko hatunui, o tōki a whānau. Tēnei mātou, ngā kaite ake, o tōki a nei tēnei wā. Tēnei mātou, ngā kaite ake, o tōki a nei tēnei wā. Ia te taonga o tāu, he awa, he whenua. He awa, he whenua, he awa, he whenua. Tēnei mātou ngā tangata o tō mō. O ngō e pā, whānu, teinana, wairu, i ni ngā. E mi atu nei kia toto kia aurora. Tie, mauri ora. In short, I acknowledge the gods above. We wouldn't be here because of them. I acknowledge the iwi, o Ngaitahu, ma te mamui, o Waitaha. I acknowledge you here today. Kia ora. And my partner, Mr. Grant, and Big Rock School Principal, and everything he does for Atokia and Brighton, and our Atokia partner. We are the guardians at this time of Atokia. We look after it, we live it. Again, we are the guardians of Atokia at this present time. The haka is to just say, hey, listen right now. There's the whānau aspect of community, wildlife, families. There's tinana, which is the physical health, and the whenua, the land. There's the wairua. Everyone brings gifts to this world. There's also religious aspects as well. And there's the mindset. So I'm just saying today, the door is open. Look after yourselves. Let's have a good kōrero today. The door is open. Te hei Māori ora, seize the breath of life. Kia ora. Have a great day.
Thank you, Dennis. All right, so there's just, obviously I've pre-filed legal submissions. and I have been catching up to the extent I can with the hearing as it has proceeded. And there's just a couple of matters that I wish to highlight in my opening submissions, and then some further matters that I'd just like to address that have arisen during the course of the hearing. The first point I just want to highlight from the opening is really the issue, which I start at paragraph 23, around mitigating the effects of odour. And at paragraph 33, I discuss the importance of the conditions capturing the key elements of or controls that are inherent in the assessment of effects. And that's particularly matters like the size of the open tip face and so on, which have formed the basis of many of the assessments of effects. Having listened to the evidence that has been presented by the applicant, in my view there remains a real lack of clarity and certainty about how the waste sorting procedure and putrescible content will be dealt with through the waste stream. I think I understand the approach in relation to the curbside collection system and how that is intended to be managed, but it remains unclear how other sources of municipal waste are to be dealt with. Now, it's my understanding that not all municipal waste in Dunedin is collected via the curbside scheme. In particular, the likes of residents living in the city centre area and apartment buildings and so on. That waste is currently collected effectively by commercial operators, and in some cases residents can take the likes of their recycling to recycling hubs. In those circumstances, I don't know whether that waste is intended to go through the bulk transfer station, and based on the description of how that process will work, I'd expect that waste is effectively just going to get put to one side, quarantined and treated as potentially special waste. So I don't think that there is certainty currently that the proportion of putrescible waste that is set out in the waste sorting procedure can be achieved. And so I think there needs to be greater clarity about that. And I think the other aspect of that, which I talked about, I think, in my opening submissions, is where waste may be brought from out of district. Other district councils, for example, who may not be deploying the same waste or curbside collection system. And so I've suggested, obviously, in my opening submission that there needed, well, the easiest way to deal with that, out of district waste at least, would be to prohibit the disposal of municipal solid waste other than that collected within the city limits, and that has been processed through the bulk waste transfer station. Now, turning to the other matters that I think have just cropped up during the course of the hearing. There was a question put to Ms. Graham about whether a community liaison committee should be a condition of consent. Now, in my submission, any commitments to community engagement associated with the exercise of the consent cannot be relied upon unless there is a condition requiring it. So whilst I, take at face value what Ms. Graham says about the intention to engage, I think unless that is secured, it is not something that you can rely on in your consideration of the consents. As you will have heard, at least from the first submitter today, that many of the community perceive that the council's level of engagement with them in relation to this proposal has been poor. And so in our view, there would need to be a condition requiring the establishment of a community liaison group to provide a clear and enforceable framework for the clarity and transparency that such a regime can achieve. It's certainly my experience that for projects like this, and AB Lime is an example, that those forums can be an excellent and useful tool for providing an opportunity for good flow of information, for the community to express any concerns, issues that are arising, and give the consent holder an opportunity to address those. And if done well, it does create a virtuous cycle that results in continual improvement of the operation of the consent holder. Turning to the question of water quality monitoring, I have to confess my undergraduate statistics didn't assist me much in understanding the evidence of Mr. Kirk in relation to the setting of trigger levels and the use of a trend analysis for that purpose. As I understood it, the intention would effectively create an almost moving target in terms of the monitoring or trigger levels through the use of a trend analysis. And Mr. Rumsby and Mr. Ife will both address the more technical aspects of that monitoring and the trigger level regime in more detail. But from my perspective, I think it is important to reiterate the view on behalf of the submitter group that the conditions of this consent need to establish the environmental and operational performance criteria that must be met by the landfill. It's not acceptable to say we'll figure them out later. Without clear and enforceable standards that are enshrined in the conditions, the nature of the activity and its potential effects are not certain. And this applies to matters such as the size of the tip face, which I understand Mr. Coombe confirmed should be limited to 300 square metres, the treatment of traceable waste, what the waste acceptance criteria are, clear environmental performance criteria to measure compliance against, controls on the likes of landfill gas concentrations to address fire hazard risk, and clear standards, objectives and processes for the construction, operation and maintenance of the key elements of the landfill's containment infrastructure. And I think it was fairly well encapsulated, I think, by the feedback that you gave Mr. Chair on the first day of the hearing. Turning to, had an opportunity to review the legal submissions filed by Forest and Bird, and I thought it might assist the panel, I suppose, to hear my view on that, those submissions. I have to say I take a slightly different view about the effect of section 43 capital B. I don't think it operates to override section 88A. However, I think it does operate, as Forest and Bird say, in that it requires the NES resource consents to be sought by the applicant. And in my view, on the face of it, and in the application, those applications haven't been made. And nor could they be, because at the time the application was filed, the NES was yet to have come into force. I worked my way back through the application documents overnight. The original application does not list the NES provisions in its Table 8, which set out the resource consents required from the Regional Council. The application simply notes the National Environmental Standard. It is this application that is addressed for the purposes of notification, and the public notice does not refer to the consents being made for the relevant activity under the National Environmental Standard. The amended application does not include an updated Table 8. The only difference is that the NES provisions are identified and said to be relevant. The language is opaque at best, and in my view does not amount to the applications being made under the National Environmental Standard. At the time that the amended application was filed, it was abundantly clear that the NES consents were required, and they should have been added to Table 8 and notified in my view. It is submitted that the purpose of Section 43B, Subsection 7, is to ensure that new national regulations get implemented as quickly as practically possible by capturing activities that may have just applied for consent but are not yet notified, and that is the case here. I think that then requires the panel to consider whether this matter needs to be deferred pursuant to Section 91, whilst the applicant makes the necessary applications under the National Environmental Standard. Now, Section 91 states that the Consent Authority may determine not to proceed with the notification or hearing of an application if it considers on reasonable grounds that other consents under this Act will also be required, and it is appropriate for the purposes of better understanding the nature of the proposal that applications for any one or more of those other consents be made before processing further. In considering whether deferral is necessary, I think it is important that you consider the nature of the regulatory framework that the NES forms part. It is a creature of the National Policy Statement for Freshwater Management, and as has been said many, many times before, this policy statement and its associated regulatory tools represent a paradigm shift in freshwater management. To allow the applicant to dodge that regime risks undermining the purpose of the National Policy Statement for Freshwater Management. Further, the need for the applications under the NES fundamentally changes the decision-making framework for this proposal. It makes the proposal a non-complying activity and subjects it to the higher threshold tests in Section 104D. It is no mere technicality, and in my opinion is fundamental to your understanding of the nature of the proposal with respect to the full decision-making regime under the Act. Now, I'd also submit that you disagreed with me on that, and that this is still effectively a ground for declining consent, pursuant to Section 104(1)(b). The strident approach that the MPS takes and the NES takes with respect to wetlands should not be ignored. This is made explicit in Section 88A, Subsection 2, with respect to plans and proposed plans, but in my view equally applies to a National Policy Statement and its associated environmental standards, which is to say that this application would now be a non-complying activity. In light of the conclusions in the Section 42A report, this is an insurmountable hurdle and must result in consent being declined. So those are the only further matters that I wanted to address you on. So I don't know if you've got any questions for me.
Yeah, I suspect we will have a number of questions for you. I'll just, Jan, do you want to start with any questions you have?
I always like to go to the last point first, so let's just do that. I mean, things have moved a lot from 2020 with the original application through to 2021 when the application was amended to avoid the wetlands. So my first question is, are you able to assist us with saying what consents you consider would be required under the NES?
So I think that the rules that are triggered in the NES are set out both as being relevant in Section 7 of the amended application and also identified by Ms Lennox in the Section 42A report. I can find the exact places for those, but they are identified in the amended application and in the Section 42A report. I think the question that you need to satisfy yourself about is whether the identification of those provisions subsequent to the notification and the original application amounts to those necessary applications having been made. And as I set out, and I'll provide you the written, I've written up the submissions in relation to this point, and I will provide that to you, but I don't, given the sequence and when the notification occurred, and if you look at the public notice, the activities that are captured by the NES provisions are not identified in the public notice. And so I think there is an outstanding question about whether or not those activities were applied for originally, and that the amendment amounts to those applications being made.
Understand that, okay. Going to the previous point, which was about the community liaison group.
Yes.
You'll know, I'm sure, from your other work that these come in various forms, and some are quite detailed, some are quite brief. A lot of them these days nominate particular people who should be on that group, and I wondered if you had any suggestions around that.
I haven't discussed that specifically with the submitted group, but I think it would be that I would expect that they would like to see at least representatives of the likes of the South Coast Neighbourhood Society. I would have thought Otakaia Creek and Marsh Trust would have an interest in being involved. Perhaps it's a question to put to the submitters that you hear from today about whether they would like to be involved. I would have thought, no doubt, Ms Ramsey and her husband, being just over the road, would also appreciate that opportunity.
Okay, well, let's just let the submitters comment on that for those who are here.
Sure.
Now, I had some questions on your written submissions, so
Sure.
we can just go to those. Not too many. I know that, I'll just put this point to you now because I know that one of your experts, Mr Rumsby, is going to talk about this, but in your paragraph 19, you refer to his evidence, and this is all about liner failure, and he gives us some examples of from places like Italy, I think was in his evidence. And it occurred to me last night that a lot of the process here, and it is already sort of coming through in the conditions, requires the construction quality assurance process to be implemented. And so you don't just get a consent and go off and build a landfill, because there's all sorts of other steps to be undertaken. So my point to you, it's not really a question as such, but in a sense that does add several layers of conservative assessment, if you like, to that process. You'd accept that, which they may or may not have in Italy, but I'm just...
Yeah, I agree.
Yeah.
There's no doubt, if the conditions are framed up properly, then they should have several layers of checks and balances in place. I absolutely agree with that. I think the question that you perhaps need to satisfy yourself of in relation to that is whether the criteria for the liner construction is adequate in light of the characteristics of this site and the types of waste that it is intended to receive. I spent a bit of time in my opening submissions on the current waste acceptance criteria and whether that is adequate. I think the particular concern that has been highlighted by Mr Rumsby and Mr Ife is this question around persistent toxic and bioaccumulative substances. And I think Mr. Rumsby will talk to this further today, but Mr. Coombe, I think, talked about the materials within a landfill being largely inert within sort of 60 years. That is only the case if you haven't enabled those persistent, toxic and bioaccumulative substances to find their way into the landfill. And so there's that interplay between the robustness of the waste acceptance criteria and the need for robustness in your liner. And if you haven't got those right, then you run the risk that your liner is effectively undercooked for the type of materials that the landfill receives.
You were involved as council for AB Lime last year, and I've read the conditions more than the actual decision, I have to confess, because I was focusing on how the conditions were approached there. And so you ended up with quite a lot of detailed waste acceptance criteria, and those conditions were quite different to the conditions that seem to be coming through for Dome Valley. I keep calling it Dome Valley, it's actually Waby Valley, but everyone knows what I mean by Dome Valley. So I just wondered if you had any comment on that, because it's like all things, consent conditions don't always look the same, but was there quite some discussion at your AB Lime hearing about that?
About the waste acceptance criteria?
Yeah, because the decisions came out almost at the same time, really.
Yeah.
So.
Yes, there was. Mr. Rumsby was one of the reviewing officers for that consent, and there was a lot of discussion during the course of the hearing about the need for the waste acceptance criteria to be improved. And in that case, it was also a question of the management of essentially the POPs and so on. From memory, because the consent that we dealt with last year for AB Lime, of course, was essentially a reconsenting to amend and remove some of the controls around annual volumes. So the landfill itself had already been established. From memory, the original consents, and I would need to check this, but I don't think they listed the waste acceptance criteria in the same way that occurred in the consent that was granted last year. The preference expressed by the Commissioner in that case was to incorporate the waste acceptance criteria as they were ultimately agreed in the end in the conditions to essentially establish the sort of baseline waste acceptance criteria. And then there was a mechanism provided through the conditions in the landfill management plan to incorporate updates to knowledge and understanding with emerging contaminants and so on. Because obviously, I mean, there is an inherent challenge in landfills in that understanding evolves over time, new chemicals are developed, and so then there does need to be a mechanism for the consent conditions to kind of shift, or the landfill management to shift with that new understanding. But yeah, the Commissioner in that sense would say, well, we need to essentially determine what the baseline is, and then we might improve from there through the management plan.
And was it envisaged, if you needed to shift it, that you would need to vary your consent to do that?
No.
No.
The intention was that effectively the landfill management plan would update the list of waste acceptance criteria to add things. If there was new information that would lead to, say, a reduction in the controls and substances that were identified in the conditions, then that would require a variation.
Right, okay.
Yeah.
You've mentioned, and I will talk to your witnesses about this, but you mentioned the 300 square metre tip face area that you've heard me raising with a number of people. Well, you haven't because you haven't been there. But
I haven't seen it on the
Mr.
tape.
Page might have told you about it.
Yeah.
if the consent was to be granted, is that sort of size acceptable to your case or your experts, do you think?
Well, I think that it's important because it is the basis of the conclusions of a number of the experts. So particularly the best example of that I think is Mr. Stacey. As I understand it, his assessment of odour emissions assumed a 300 square metre open tip face. And so if you're to accept his conclusions that odour emissions will be acceptable, then that is on the basis that the open tip face is 300 square metres. So, I mean, I don't think I can say that there will be any conditions that will be entirely acceptable to the group of people I'm representing, but I think it's important that where you're relying on that evidence and its conclusions, that the condition reflects the key constraints that those assessments assumed. And I know from my work with other landfills that the open tip face and its size is one of the key ways that you manage odour emissions, litter, all of those kinds of things, and things like, you know, leachate generation and so on, because it's not covered, so you get heavy rain, you're getting more infiltration in those areas. So it's a really important part of the landfill to be managing closely.
Okay. Over in paragraphs, this is sort of 28 through to 30 or so, you were criticising the condition that had come through to deal with odour control. And I went back because I was trying to remember where the condition had come from, and it seemed to have come from the Tonkin and Taylor Section 95 report, where they sort of played with the words and changed it all around. So, and then the applicant accepted what they'd said, and so we sort of had the peer reviewers coming up with the wording. So I wasn't surprised to see that, because I was just trying to sort of trace the paper trail, if you like. But what is the real problem with that wording for you? The
problem is that we're essentially saying that odour that is offensive and objectionable can be discharged beyond the boundary, so long as we determine whether that has adverse effects or not. So it seems to me the condition's creating an extra layer of evaluation and effectively authorising the discharge of offensive and objectionable odour beyond the site. And in my view, it creates, like, we shouldn't be enabling the discharge of offensive and objectionable odour beyond the boundary, irrespective of adverse effects, but it also creates a layer of uncertainty that will require, I suppose, more evaluation about whether a breach of that condition has occurred. I think it's much clearer if we simply say there shall be no offensive and objectionable odour beyond the boundary. So if there is some, that's the end of it. Doesn't then require the calibrated nose to decide whether it gave rise to an adverse effect or not.
Okay. Paragraph 38 B. I was sort of a little amused by this, in the sense that you had just got the tonnage limit removed from AB line, and here you were today saying that one should be imposed here if consent was to be granted. And so my question really is, why would that be? If you've actually got a whole set of complex consent conditions, why would you need to be limiting the waste tonnage?
Yeah, so I think it's again, in the AB Lime scenario, we were dealing with a landfill that was already operational, and although we were seeking to remove the tonnage limit there were other constraints at the site that effectively put a cap on how much they would be able to ultimately receive within a year. So here, we don't yet kind of understand, or we can't see how operationally this landfill will sort of settle out. And again, it strikes me that many of the assessments of effects are reliant on some assumptions about the volume of waste that is likely to be received. And so if we're to ensure that the conditions keep the activity within the envelope that has been assessed in the effects assessment, then we need to place that sort of crude control on the scale of the activity.
Okay. I'm not going to ask any questions about the bond because I've already raised this with the applicant and left them to go and do some work on that. I see that AB Lime, though, had a specified sum put into its consent conditions,
Yes.
and a lot of the others have a sort of formulaic approach. And so was there a reason why you ended up with a specified sum?
So this, from memory to that, was attached to the land use consent that was held by the District Council. And the decision was made that that would get re-looked at when that permit came up for renewal. And so it was a creature, in that case, of essentially the, because there's two parts to this in AB Lime's case, there's the land use consent with the District Council, and there's the arrangement they have with, I can't remember the name of it, the council, the district councils in the area have a waste company that does all of their waste collection, which is contracted to AB Lime to receive the waste, and that is a commercial arrangement that deals with some of the other bond-related issues. So there's sort of that sitting in the background in that case, and the commercial arrangements are sort of all worked around the that land use consent. So the Commissioner accepted that it was appropriate to deal with the bond in that context rather than the regional council permits. So I think there is, my sort of view on the bond issue is that the sort of Cape Valley model of assessing what actually is up for grabs or would need to be addressed at a particular point in time in the exercise of the consent is probably preferable, because it means the bond size kind of moves with the activity and the level of risk that might exist at the time, and it also allows for effectively inflation to be accounted for. I think the risk with setting a bond at the start of a 35-year consent is that the value of it by the end of the consent perhaps doesn't come close to covering the costs that might arise.
Yeah.
So I do think probably that type of Cape Valley approach is the preferable one.
They had quite a few issues with that in Coromandel Mines a few years ago, where they had set sums and then found many years later, as things all started to go a bit pear-shaped, that the sum was not very helpful in dealing with that. That's all I've got for you. Thank you very much.
I've got a couple of questions for you based on your written evidence, and if I may take you back to the Odour issue, just following on from some of Jan's questioning. I note that at paragraph 31 you mention that there's no specific odour monitoring proposed. I was just curious about just teasing that out a little. I'm aware that the applicant has put forward a condition that would require a walkover site inspections must be undertaken at least monthly, and the wording in that condition appears to be based on any evidence of landfill gas odour. Must be investigated, so it doesn't seem to require that extra evaluative adverse effect assessment that you were concerned about. And just wondered if you had any comments on that condition, or indeed the other gas monitoring proposed to detect gas leaks and the complaints.
Yeah. So as I understand the walkovers, they kind of do it with a wand that helps identify whether you've got heat and stuff coming out of the landfill cap, and it's more about ensuring that the landfill cap is functioning properly. And that will have some advantages from an odour management point of view for sure, because as I say, the hydrogen sulphide component of landfill gas is that rotten egg smell that people don't like, and so if you can really manage the landfill cap properly, that really helps in terms of managing odour. In the case of AB Lime, and particularly some more recent landfills elsewhere, there has been hydrogen sulphide monitoring sensors put in place, which provide, I suppose, a layer of protection where, if you're only walking over monthly, then something might happen. You can't see it, so the guy sitting down at the weighbridge or whatever isn't going to spot a landfill gas leak in the cap from sitting down there, so you're relying on that monthly. So if something crops up in the interim, then the hydrogen sulphide monitors provide essentially a safety net to capture that. In the AB Lime situation, the trigger level for the hydrogen sulphide monitors is effectively below the level that the nose can pick up. So if they see that starting to happen, they know they've got to go out, figure out where that's coming from, and it essentially prevents odour being emitted that people can smell. So it's a really useful tool to allow them to get on top of issues well before they actually risk giving rise to adverse effects. And that's equally important in relation to managing the landfill gas and making sure that the likes of the flare continues to operate at the right temperature and all of those sorts of things.
Okay, thank you. I see, that's really useful, thank you. The other question I have for you relates to paragraph 8, where you've raised some concerns around the impacts on freshwater species in relation to the effect on Māori cultural values. So I'm interested, we're hearing from Edward Ellison next week on behalf of the Runaka, and I'm just interested in terms of how the concerns that you raised might reconcile with the evidence of Mr. Ellison in terms of representing Mana Whenua's interests. And so any comments you had on that would be useful.
Well, I think this issue arises about in terms of whether the application has adequately assessed the risks associated with contaminants emanating from the landfill, and in particular these persistent pollutants that could essentially occur in very low concentrations but that bioaccumulate in freshwater species. So the evidence from Mr. Rumsby in particular is that there is a risk of these persistent pollutants essentially making their way out of the landfill, and that they don't need to reach levels in water that make the water itself problematic, but that they potentially bioaccumulate in species. And we know, as he sets out in his evidence, that eels are particularly good at accumulating some of these substances, and they're species that the evidence of the smitters shows are collected in the receiving environments of this landfill. So that is not an issue that appears to have been addressed in the assessments done by the applicant. And so Mr. Ellison may not have been aware that this was an issue that could arise as a result of the application. So I don't know what he would say about whether there is an issue if these species are to bioaccumulate these substances and become effectively inedible.
Okay, thank you. That's what I have.
Just got a number of things I'd like to ask you about. Just following up on that last issue, you'd agree though, wouldn't you, that in terms of, I guess, a definitive view on Māori cultural values and interests, we should defer to and give weight to the submission and evidence of Te Rūnaka?
I think absolutely it deserves weight. I think you need to be confident that they have understood all the potential effects on their values. So if you were to agree with the evidence of Mr Rumsby that there's a bioaccumulation risk here that hasn't been appropriately assessed in the application, I do think you need to factor that in to whether mana whenua have had the opportunity to consider all the potential risks of this activity on their values.
So is it your submission to us that ukaha who act on behalf of Te Rūnaka haven't fully understood the application that they've reviewed on behalf of the applicant?
Well, no, I'm not suggesting that, because I think, as Mr Rumsby says, this issue hasn't been addressed in the application. And it is quite possible that it wasn't an issue that's been identified by our kaha, because it's a really specialist sort of area. The issue's been raised by experts for the submitters, and doesn't really seem to have been directly responded to by the applicant's witnesses, to be fair. So I think there is an outstanding question about this risk of persistent pollutants and the bioaccumulation within particularly the Otakaya Creek.
Okay. Let's take you back to your paragraph 2 now. And just some specific questions. So your paragraph 2C, Romans 3, where you say, do not ensure that the costs of remediation work can be met. What costs of remediation are you referring to there?
So this is effectively the bond issue. So if something goes wrong,
Right.
there's currently nothing in place to ensure that those issues the cost of remediating those issues can be met.
Yeah, no, that's good. Bond issue, that's fine. I thought you might have been referring to something else.
No.
Just a minute. And the very next line, 2C, Romans 4, adequate environmental compensation or offsetting. What are you referring to there?
So that's really a reference to the discussion and the evidence from Mr Lloyd, and whether or not the likes of, I think it was the kahikatea plantings within one of the wetland areas was going to have the appropriate ecological benefits given the risks posed by the changing hydrological conditions. So I think that's a matter that perhaps you can explore further with Mr Lloyd. I think the evidence, I think, of Mr Hutchin also talks about the benefits of the mitigations for the likes of I think it was the skinks, and whether those are sufficient.
Taking you now to the top of your page 5, paragraph 6C, and the very last part of that paragraph where you discuss the Green Island discharge permits. You're not suggesting they're within the scope of our jurisdiction, are you?
The Green Island discharge permits are not, but I think consequential effects of this application are.
In paragraph 10A, you talk about good quality groundwater. Can you just remind me what consumptive use is made of the groundwater that underlies the designated site?
I think Mr Ife identifies where the nearest groundwater bore was in relation to the site,
Yeah.
and he does acknowledge it's not particularly close. So I don't think there's consumptive uses of the groundwater at the site or in really close proximity to it. But I think the evidence of Mr. Ife is that where you've got potable water, you should try and look after it, irrespective of whether it's being used now or not.
And just a couple more, or 3 or 4 more. Paragraph 14. I'm not quite sure what your submission to us is here. My understanding of our assessment process in terms of discharge consents, which are the consents that have been sought by the ORC, from the ORC, and so they're the matters before us, is that we need to think about where the applicant effectively loses control of the discharge for which they've sought consent. And in this case, that would be where discharges from the attenuation pond or the sediment pond into the swamp wetland, and for groundwater, probably much the same receiving environment. Are you suggesting that in terms of assessing the effects of those discharges, the New Zealand Coastal Policy Statement is relevant?
I think if you accept the evidence of Mr. Rumsby and Mr. Ife, that there are potential issues associated with the bioaccumulation of contaminants in freshwater species within the coastal environment, then yes, I do think this engages the National Policy Statement.
You got any kind of precedent that you can refer us to in that regard?
The one I can think of is a recent judgment of the Environment Court in relation to a water permit in Clutha, so I can provide you that. It's effectively a question around consequential effects of an activity.
No doubt we'll hear from Council for the Regional Council and the applicant in that regard. So I look forward to looking at that as well. Just your paragraph 17 where you talk about uncertainty. And I think you're relating there to the sole objective of the NPSFM in terms of the hierarchy of priorities. I mean, that doesn't rely on uncertainty, does it? I mean, that hierarchy, we have to implement that hierarchy just as a matter of course, don't we, in terms of discharge consents to surface water?
Yes, you do. I think what I was pointing to there is the interplay between achieving the objective and the best information provision, which basically, I suppose in summary, says you've got to work with the information that you have, even if it's not as good as you would like. Where it isn't as good as you would like, you need to make a decision that best implements or achieves the objective. And so I think that where there is uncertainty, you will tend to be more cautious as a result of that direction and the best information provision.
Just coming back to this odour condition, there's already been some discussion of it. I mean, this kind of condition is extremely common and it's worded a little bit differently all around the country. The most common approach that I'm familiar with is it's to be no offensive or noxious discharge of odour beyond the boundary of the site as verified by a council compliance officer. And in fact that's the outcome you achieved for the AB Lime consent. So you'd agree that's appropriate here?
Yes, I think so. Yeah. I mean, in my experience, certainly with these sorts of things, people will call the council and say it stinks, and the council will send out a calibrated nose.
Yeah. No, that's good. Just a couple more, just to clarify. 42B. Very last line of existing wetland extent. Which wetland are you referring to there?
The swamp wetland.
Okay. Yep. Good. Now, just coming back to the issue raised about the NES FM, just a couple of matters there. I'm not sure if I understood what you were saying correctly in terms of whether or not that means that we can or should have regard to the MPS FM.
Mm-hmm.
That's front and centre regardless of this issue on the NES.
Yeah, absolutely.
Yeah.
Yeah.
Now, I just can't recall, in terms of the applicant amending their application, I mean, they lodged pre the NESF commencing.
Mm-hmm.
So at that time, there was no need to obtain consents under the relevant regulations of that document.
Mm-hmm.
Later on, they then amended their application, but they didn't withdraw and lodge a new application, did they?
No, they didn't.
No. And it's very common for applicants to amend an application, and in this case they reduced the nature and scale of the activity and therefore its effects.
Well, I don't know if I'd accept that necessarily.
They reduced the nature and scale
They
of the
certainly
operation.
reduced the size of the landfill. Whether that results in an absolute reduction in effect, I'm not sure. It certainly avoided the prohibited activity issue that they would have otherwise had to confront and has made it a non-complying activity one.
Mm-hmm.
I mean, there are always, in my experience, shades of grey around the extent to which you can amend an application and stay within the envelope. And I think here, given the way that Section 43B operates, effectively there were new consents required at the time that the amendment occurred. And I don't think it is clear off the face of the documents that the amended application sought those consents. So I think that's the question you need to answer for yourselves. And I think that the issue is made more murky by the fact that the notification took place prior to the amendment. And so those were the matters that were out in the public as being up for grabs from a consenting point of view. And that didn't, in my read this morning, identify the regulations in the NES as being something for which consent was required. And of course...
And again, we'll receive submissions on this, I'm sure, from the regional council and from council for the applicant. But we'll see where we go with that. Did you have a follow-up?
Yeah, just want to ask a follow-up question. I had understood the application was notified last year. So
Yes.
I've seen a couple of comments actually in the last, it was actually in the Forest and Bird legal submissions that it was notified in 2020.
Yes,
But
yeah, so from
I
memory,
don't recall it being
the
notified
application
2020.
went in just end of August, and the notification occurred, I think, on the 13th of September.
No, I don't think that's right. I'm sure that Ms Lennox will correct me if I'm wrong, but I don't recall it getting to notification then because a lot of reports and Section 92s and all sorts of things went on for quite a while. Then the application was amended in May or something, and then there were a whole lot of notification reports prepared by Tonkin and Taylor particularly, and Ms Lennox, and for the District Council as well, and they all seem to be coming together about August to September last year, and then the notification followed. Is that right? Yeah. So, yeah, the whole thing about notification in 2020 is...
Right. Oh, well, I might have got
No.
those dates mixed up.
Yeah.
It is quite hard to trace through on
so
what's
the
available on
amendment
websites.
had already been made before notification.
Well, if that's the case, then I think my point around the notification muddying the waters may not be correct.
Right.
But I think what you need to satisfy yourself of is that the amended application amounts to seeking those new consents. And I suppose a question of whether or not that falls within scope, given the way that 43B operates.
Would you be, are you submitting in all of this argument that in light of the new consents that you say were required, that it should have been re-notified?
Yeah, possibly. Yeah. I know certainly my experience, particularly in the likes of Southland, where the new rules have come in around intensive dairy grazing and all of those sorts of things. Applicants in those cases have been required to resubmit applications that are now captured by those rules. I think there is a question here around whether or not the applications encapsulated the activities that the NES covers. I think the issue here is that there's sort of no corresponding rule in the regional plan that existed prior to the NES. So there's sort of no substitution of consents being sought that can be easily made. But I think at the end of the day, there may not be a lot that turns on that, because I think of the impact that these can, the NES has and the NPS framework has on the assessment you need to undertake under Section 104.1b. And I think it could be a scenario where, that Section 104.1b analysis is really the key aspect of your analysis for the purposes of this application, given how much has changed.
Anything else?
No, thank you.
So just coming to, I guess, what you are wanting to achieve through your submissions on this point, are you submitting to us that we should defer the application and await these NES applications to be made? What exactly are you asking?
Well, I think there's a question you need to answer in that respect about whether or not you think you have the information in front of you seeking consents for those NES permits. And if you haven't, then I would say that a 91 deferral would be appropriate, because, as I set out earlier this morning, of the significance of those applications being required on the assessment framework for this consent. If you don't think that those applications have been sought and you can't grant them, then if you don't defer, the council's left in the position where it will need to come back and seek those consents later. And of course we all know there's a general preference to ensure that all consents relevant to an activity are sought and obtained together, so that you can understand the full scale of effects.
Sure, but it's reasonably common in my experience for an applicant to have to come back and get consents for other activities or more detailed activities, and particularly with a major infrastructural project such as this. In my mind, the key issue is Section 91.1b, that we might consider deferring if we thought that would give us a better understanding of the nature of the proposal.
Yeah.
So what information are you saying is not currently on the table that a 91.1b process would reveal for us?
Yeah. I think it's a question around what you consider the nature of the proposal to encapsulate, and I think because of the significance of the change in activity status, that does change the complexion of your assessment under the Act. So you go from just a discretionary consent where you can grant or decline to one where you have to assess whether or not the application needs to pass the Section 104D gateway.
Sure.
Like I said, it's not a mere technicality, that change.
Yeah, but we have to look at whether or not the effects are minor and consideration of the statutory instruments regardless of that.
That's right.
I don't think you've answered my question in terms of what information would we think could be achieved under a Section 91.1b process that's currently not on the table?
I think in terms of information about the activity, it won't yield anything new. But that change in activity status, in my view, is a significant change in the nature of the application. So that would be the basis on which I think a 91 deferral would be appropriate. But I acknowledge that under Section 104.1b, that aspect can be taken into account via that 104 framework in any event.
All right, thanks very much. I don't think we have any further questions for you.
Great.
So I imagine you're going to be the master of ceremonies for your witnesses.
Yes, yep.
And do you think we'll get through one before 10:30, or would you rather take an early morning tea at this stage?
So Mr Rumsby is the first witness up.
Yeah, we'll take an early morning tea, and we'll come back at 10:30, thank you.
Very good.
Right, good morning everyone again. If I could ask you to take your seats and cease your conversations, it'd be appreciated, please. And I'm not sure if we made the mask wearing rules clear to everyone at the commencement of the hearing. So the procedure here is when you're sitting down in your seat, you don't need to wear a mask. If you're speaking to your submission or evidence, you don't need to wear a mask. But if you get up and walk around, you're supposed to be wearing a mask. Of course, if you're drinking a cup of tea, you don't have to have your mask on. So normal kind of processes. Right, Ms. Irving, back to you.
Thank you, Commissioner. So the first witness I would like to call is Mr. Rumsby, and he will be joining online.
So good morning, Mr. Rumsey. Can you hear us?
Yes, I can hear you clearly. Good morning.
Good morning, and we can see and hear you. So thank you very much for your evidence. I'm not sure if you've been tuning into the hearing on Zoom prior to now, but you don't need to read your evidence aloud to us because we've read it. So that would be a waste of everyone's time, but you're very welcome if you wish to highlight key points, or if it's your preference, we can go straight to questions, but that's very much up to you.
I've been listening to the evidence of Mr. Coombe and Mr. Kirk and Mr. Welsh and Mr. Dickinson, and I guess I would like the opportunity to provide some comments on that if you believe that is appropriate.
Yep, sure. So the general approach is if you think it would assist us in our decision-making role, then you're welcome to comment on the evidence of other experts.
Yeah. I guess the other thing I would like to state, because Commissioner Porter mentioned it briefly a little bit earlier, I was involved in seeing the waste acceptance criteria for AD Line, and I was involved in Dome Valley waste acceptance criteria and human health risks as assessing Section 88 matters and Section 92 matters. But at the end of that process, I left PDP and Natalie Webster took over it. So I was not involved in the final setting of the waste acceptance criteria at Dome Valley. So the first thing I would like to talk about is whether the assessments that have been done to date and the design of the landfill liner are actually site-specific. Mr. Kirk said they have done a site-specific assessment, and Mr. Coombe made the statement, I have designed the liner in accordance with Wasteman's guidelines. And I also noted that Commissioner Odour noted the process may have been backwards in the design phase. So the first thing, and it's not in my evidence, but I think it's important to note, is the introduction to the Wasteman's guidelines. And what it says is that there should be a comprehensive site-specific assessment of the effects on the environment. I don't believe a comprehensive site-specific assessment has been done. These guidelines do not reduce the necessity of development of a site-specific requirements for investigation. This is where I think this is important. Design and the word operations. And I don't believe the design and operations in all its aspects are site-specific, and monitoring. The other thing that's in the introduction to those guidelines, it notes the guidelines are not intended to be a detailed technical manual, but a source of information for which the facility operators and regulating authorities can seek comprehensive technical planning and legal advice from the appropriate qualified experts. So the first thing is, why do I think it has been a site-specific assessment? And there's several things, is that it boils down to they haven't had the information to do a site-specific assessment. And one of those things that I think, when it comes to designing a liner, is you need to understand the seismic risk and the risk that it can place on the liner, because it affects your design. Because lateral movement in an earthquake can rupture the HDPE liner. There'll be a mode of failure, catastrophic failure. Understanding the risk from a comprehensive cyber risk report, I think is fundamental in deciding, well, what liner thickness do I need? What is my service life of my engineering service life of my liner? Because if you've got an earthquake event that's going to rupture every 50 years, you can't claim that the service life of that HDPE liner is 446 years. And all those things become really important when you're considering what sort of waste goes into that landfill, and how thick your clay-based liner and etc. need to be. So it has all sorts of implications. The second thing is that they have not done an assessment of risk from bioaccumulative substances, both on the environment and for human health. Now, I've heard people say that, when we get further away from the landfill, the concentrations will dilute and this will not be a problem. Well, that's simply not true for a bioaccumulative substance, because they bioaccumulate through the food chain, and the issues are dietary toxicity issues. And you need to consider some quite complex site-specific interactions. So, for instance, some species may move up and down the stream, and some of them may move downstream or change to becoming waterborne organisms to airborne organisms through different stages of their life. And that can actually result in the transfer of contaminants. The other thing is that further downstream, the trophic levels might become way more complex. My expertise on bioaccumulation are primarily limited to mercury and PFAS compounds. But I have seen significant bioaccumulation occurring many kilometres downstream from the release source that weren't necessarily evident closer to the release source. There's one case at Ohakea, we had to evacuate chickens. Now the chickens weren't on contaminated land, there was no soil there. The water they were drinking didn't have any contaminants in there, down to 10 picograms per cubic metre. So parts per quadrillion levels we were able to analyse down to there. Incredibly small amounts. To put that in context, I think we were getting down to the equivalent of putting one drop into 1,000 Olympic-sized swimming pools. Was the levels we were trying to analyse down to at that point. So they are minute. And we don't see criteria, the waste acceptance criteria, or any of the calculations that Mr. Kirk has done for PFAS or some other compounds, and some of them are just very limited. There's no evidence that bioaccumulation has been assessed at all anywhere in this assessment, and certainly not to the level that I believe will be necessary for a site-specific assessment. And why this becomes a problem is sometimes we're talking about incredibly trace amounts of contaminants. When you do a hydrogeological model, such as what Mr. Kirk has done, they're looking at bulk parameters, and they're assuming that the liner will perform at 10 to the minus 9 everywhere within the liner, because that's the parameter he feeds into the model. In reality, you don't actually need a very small failure of this and actually having a very small amount of contaminant getting through a small lens to cause a problem. And I guess what people haven't never really realised, say you take Ohakea, you take Woodburn, Ohakea was only 50 kilograms of PFAS released over 30 years. Woodburn was less than 10. Estimates somewhere between 1 and 10. You know, they weren't very huge amounts of those compounds escaping in those environments and being transported many kilometres away from the original source zones. There's a lecture that's given by Dr. John Cherry, who's considered the father of contaminant hydrology. And he goes, he says, aquatards stop water, aquatards don't stop denapples. And what they're effectively trying to build here is an aquatard around the landfill with the liner. I mean, if you want to, I do actually have a link to that presentation that he gave via YouTube, and I could forward it to the commissioners. I actually find it quite an interesting talk, and you can jump to a section on it where it actually just talks about that.
Mr. Rumsey, I might just interject there. We can't receive YouTube clips as evidence. We would need to hear from the expert who actually gave that YouTube clip so we could establish the probative nature of that evidence and ask questions. So that's not something we can do, but thank you for the offer.
Okay. So, what would normally happen, and what happened, say, at Dunedin Valley, for instance, there was a risk assessment looking at various modes of failure, what's the likelihood and consequences, and then that then informed the design and the waste acceptance criteria for that landfill from the submission. I have seen no evidence that a risk assessment, a complete holistic risk assessment of the project has actually been undertaken. And that risk assessment would need to estimate reasonable maximum exposure for a variety of contaminants and also the most likely credible failure scenarios and the maximum credible failure risk from various components, such as the leachate collection system blocking up, etc., etc. Line of failure, whether catastrophic or gradual. I have seen no evidence that's been done. So, is the liner actually even an appropriate base design for consideration? And then there's uncertainty about the constructability of the liner, I'm hearing from Mr. Coombs' evidence. And that's important when considering the release of these POPs. Because if the liner does not meet that 10 to the minus 9 scenario, then, and there's some areas, it doesn't have to be big areas, just some areas that are not up to that standard, contaminants will be released at a higher rate for those areas. So effectively, for Mr. Kirk's models to be correct, they would have to achieve perfection in the treatment of the loss to make it a suitable liner. Is the effective assumption using Mr. Kirk's models. Otherwise, the risk is actually greater than he's predicted. Generally, once you've done the risk assessment, there's a bit of an interplay between, well, I want to exceed these wastes and what sort of liner design that I want, because your waste affects what can happen to your liners. And it also...
Mr. Rumsby, can I just get you to pause for a moment? Ms. Irving, so the point of this kind of presentation is for your witnesses to respond to things they've heard the other experts say verbally during the hearing. In terms of sequence, their evidence came after the applicant's evidence, so we don't want to have a repetition of the evidence we've already read. But if the experts wish to comment on things the applicant's evidence witnesses have said during the hearing, that's what this opportunity is for. So could you just make sure that the two other witnesses follow that protocol? And Mr. Rumsby, if you could confine your comments to commenting on things the applicant's witnesses have said during the hearing, rather than repeating things in your written evidence that you wrote after reviewing the applicant's experts' written evidence. I'm not quite sure if you're sticking within that band at the moment.
I was trying to explain my rationale for why I don't believe the applicant's statement that a site-specific assessment has been conducted, and why I don't believe that compliance with the Wasteman's guidelines, as Mr. Kuhn indicates, actually meets the requirement of the site-specific liner. And the reason why I'm expanding on that a little bit, because the process has been done the wrong way around. You know, you do not have that seismic risk assessment. You have not done that by a cumulative impact, so you don't know what line of performance needs to meet, and you have not done that basic risk assessment for the overall project and what are the failure modes to understand service life. And from that, it comes out to, was the liner appropriate? That's been submitted for consenting, and is the management plan that's been submitted, which has no information about the inspection and monitoring requirements and preventive maintenance plan of the under-drain leachate collection system. I guess the other thing I'd like to say about Mr. Kuhn's evidence, he said that he focused completely on blockage of the drainer, the pipe work. What he didn't say, and there's nothing in his evidence about this, is that blockage occurs in that granulated layer as well, and that affects the hydraulic conductivity of that granulated layer, which means the hydraulic head above the length of leachate above the liner increases as that hydraulic conductivity decreases. And that has implication on leakage rates. I don't think there is a very robust preliminary design, and I don't believe that the appropriate preliminary design process has been followed. We seem to have only a very generic design for a landfill liner that is basically taken word for word from the Wasteman's guidelines, the sample spec, and the Wasteman's guidelines are not a design manual, nor do they actually fully outline the requirements. And the other thing that I've never heard anyone state is, what is the design like for the leachate collection system and what is the design like for the liner? And that's really important to understand if you're accepting persistent organic pollutants into the landfill. Because if the engineering life is much less than the lifetime of those persistent organic pollutants, then you're going to have a situation where the engineering controls have failed, but those persistent organic pollutants are still being released. I disagree with Mr. Kuhn's statement that at 60 years, the landfill leachate is essentially inert. This is not true for persistent organic pollutants, because under the definition under Stockholm, the half-life of anything to be classed as persistent has to be 5 years. For it to be considered inert, you must go through 10 half-lives. So the minimum, anything classified as a persistent organic pollutant under Stockholm would still be leaching for at least 50 years, and with PFAS compounds, we have not been able to establish a half-life. So they've been, you know, it is much, much longer than 60 years, and most of those pops would be releasing after 60 years. So I disagree with Mr. Kuhn on that particular point. That's probably all I want to address about whether our site-specific assessment has been done and whether it's actually adequate. Mr. Kirk stated that the PFOS guidelines were draft and therefore not used. That's not actually correct. They have not been formally published by Water Quality Australia, so they do not appear in the Australian New Zealand 2018 Water Quality Guidelines. Where they have been published as a final form is in the National Environmental Management Plan for PFAS. They were published in version 1. They were republished in version 2. Version 3 is currently being drafted and is at a limited release. They remain the same in version 3. And that will be coming out later this year for public consultation. These guidelines may update in the future, and I know some people believe they should, but they aren't to be considered as draft guidelines. They're being used regularly in assessments in New Zealand and Australia for PFAS. So they are appropriate to use. This is, I'm afraid I'm going to have to get very technical here on this part where we're talking about minimum number of samples and trend analysis, because I have to go into statistics to refute what Mr. Kirk said. One of the statements Mr. Kirk states is that his approach is consistent with the USGS 2020 guidelines approach. I disagree with that statement. It does not state, as he says, that a 3-year program done monthly would be sufficient with only 12 data points for trend analysis. And they also state that the man-Kendall analysis, which he stated as a possible tool to use, wasn't quite sure what they're going to be using for them, is not appropriate to use when there's seasonality. But he called a man-Kendall seasonal analysis, but man-Kendall is not an appropriate tool for seasonality because and this is what it actually says in the USGS guidelines, because the trend tests are fundamentally about being able to see a trend seem to stand out above the noise. This seasonality will hinder our ability to truly observe the trend. So, therefore, man-Kendall test is not a robust test. That's just my conclusion rather than another quoting. If seasonality is expected to occur, there's nothing to say that only three events are needed for seasonal monitoring. And this is where I get confused with Mr. Kirk, because he talks about man-kindled seasonality analysis. It does not exist. There is no statistical test called man-kindled seasonality analysis. There is something called a man-kindled analysis, and there is something called a seasonal kindle test analysis. And it's that seasonal kindle analysis is what the regional councils use in their trend analysis for long-term SOE monitoring. And that's what the NEWA guideline provides advice about that I quoted. But what the USGS basically says is that the product of the number of seasons and the number of years needs to be more than about 25 before you attempt to use that tool. So if you've got 3 years and 4 seasons, so quarterly monitoring times 3 years, that number is 12. That is less than 25. So if you read the USGS guidelines, it says it actually is not an appropriate approach to use the seasonal kindle tests. Generally, the USGS documents talk about greater than 5 years with the data, and that's in line with what NEWA says for the National Environmental Monitoring Standards. In an earlier tech note, USGS technical note number 6, and that's the national standard for non-point source monitoring. It says if you've got we do trend analysis on something that has no seasonality, and if you've got a short amount of data, and it gives the example 3 years is a short amount of data, it says that analysis of covariance is a more appropriate analysis than trend analysis. So this using trend analysis on the 3-year data would not, within any statistical advice that I've ever seen. Mr. Kirk quotes a US EPA guidance that says that he's used this as basis, but I'm unaware of what that guidance is that he's referring to. He's never given a reference for it. The closest thing that I'm aware of is a US EPA guidance document called the Assessment of Plume Stability and Monitored Natural Attenuated Assessments, which does use a man-kindle analysis, and it states that you need a minimum of 3 data points because otherwise that statistical tool won't work, and a maximum of 12. That's a tool being used for a completely different purpose for here. I don't believe it's an appropriate tool. You could ask my colleague, Mr. Irvine, about that as well. He has considerable experience in this. And I don't even think that trend analysis is an appropriate tool for setting trigger levels. And I've had some experience trying to enforce a condition with the trend analysis being, and it is practically unenforceable until that sort of stream. You know, there was one of the issues was, there was a trend in one data point, but there wasn't a trend in other data points. So it wasn't clear when that threshold was that to actually enforce the consent, whether it was only a trend that you observed in one point, or did you need every single parameter, or only a few, or were there only a couple of key parameters that had to extend a trend. The basis of a trend analysis, the null hypothesis, is that there is no trend. So you have to build enough evidence to reject that null hypothesis. So when you have a leak, you can actually see a large change. I saw this in some landfills and some other sites that I've either been involved with assessing the data or I've used them myself. We can see a large change in the data set, but the trend analysis doesn't actually show it until several monitoring events less, because there hasn't been enough data to reject the null hypothesis. So they can actually be quite insensitive for detecting a change where you can see it obviously looking at a graph. And there's also problems about when you have non-detects in your data set. Man Kendall can only handle 1 or 2 non-detects before it really doesn't work anymore. And that's a point brought up in USGS guidance documents. So I do not agree with Mr. Stewart that trend analysis is an appropriate tool to set trigger values. I don't believe that they will even offer a certainty about the level of protection they're going to offer. Because if you have a background that's already close to a guideline value, the trend analysis doesn't take into account the guideline value. It won't take into account whatever attributes are assigned for nitrate or dissolved oxygen. It'll just be telling you whether there's an increasing trend or a decreasing trend, or if there's insufficient evidence to support the conclusion that a trend is present. That's all a trend analysis does. So, again, I think this is the wrong tool to use when you try to set some sort of trigger limits to take action on. They can be useful to understand whether something's occurring, but I think they are most definitely the wrong tool. The other thing with the application is that there's no sampling analysis plan being presented with this application about it. So when they're going forward, we're going to do this background sampling, I don't know how they're going to collect the samples. I don't know what detection limit they're going to analyse the samples for. And some parameters, SVOC and VOCs, I don't know what parameters they're actually going to analyse for. And looking at the revised consent, I think they're actually looking at the wrong parameters. And I don't know what the quality assurance program is going to be put around this program as well. And they're all important things to understand, and they could have been easily done beforehand, you know.
Mr. Runsby, sorry to interject again. I'm still not sure you're addressing points that were raised verbally by the applicant's witnesses. I've just reviewed your pre-circulated evidence, and you did have a couple of pages talking about trend analysis and your concerns with it. Can you just make sure, because you've been speaking now for 35 minutes, and I'm not wanting to unduly cut you off, but if you could just refine the remainder of your comments to commenting on matters that were raised verbally by the applicant's experts during the preceding hearing. We've read your evidence, we'll have some questions for you on that, but if you could just bear that parameter in mind in terms of what you address us on verbally for the remainder of your speaking time before we turn to questions. Okay,
I'll do my best. Now, Mr. Walsh raised the appropriateness of setting a 5% oxygen level. And he proposes a landfill gas operation and management plan to prepare. I agree with that 100%. But I also believe a 5% oxygen level should be placed now on the consent, so I haven't changed my view. And that comes around with the fact that the lower limit of flammability of oxygen is 12%. When you set a trigger level, you're going to have to set a safety factor. The minimum safety factor you're going to apply is 50%. So you're at a guideline level. It's only going to either be 4%, 5%, or 6%. And that's really just splitting hairs whether they want 4% or 6% or 5%. So I don't believe they're going to come to any different conclusion than I have, which is that a 5% oxygen limit could be set. And I can't see any reason for delaying setting that limit and the consent at the moment. Switching to Mr. Dickerson's evidence about lithium batteries, whether they should be a prohibited item or not. He basically says we shouldn't put a prohibition on the lithium batteries because it's unachievable and there's no way of getting them out of the domestic waste stream effectively. I believe if you look at Mr. Henderson's evidence that he presented earlier when he's talking about removing food waste from the waste stream, he has this comment. It's an issue, but it can be solved through education. And I think that is also true for lithium batteries. If you have concerns about the enforceability or the overdue harshness of prohibiting lithium batteries from the waste stream, a consent condition for AB line was imposed on that, which sort of dealt with these occasional little button batteries that you might get in someone's rubbish. And really my evidence is not really focused on if you get a small little button battery going into the landfill, because it's not enough mass in that button battery to cause a catastrophic issue. But it's the larger battery in those commercial waste streams, etc., when you're getting large car batteries and e-bike batteries and those sorts of materials going in when you've got much larger mass, and that I'm concerned about causing a larger landfill fire. My other concerns have to do with the wording of what I've seen in the proposed consent condition about what's going to be monitored. Is it appropriate for me to make comments on that?
Well, only if you're responding to verbal evidence that's been given to us during the hearing. If you're responding to the applicant's pre-circulated written evidence, then no.
But it was stuff that I received during the hearing as written evidence.
So what exactly?
So I didn't see it in my submission, but it came through its revised consent conditions.
So you want to comment on Mr. Dale's revised consent conditions?
Correct.
That were attached to his evidence?
It was only circulated to me afterwards, so I only got them on Tuesday.
Well, it's Ms. Irving, I mean, this is up to you. This witness has taken 40 minutes now. I know you've got a lot of other witnesses to get through today. We've yet to ask our questions of this witness. You've got two more technical witnesses to come. I'm not sure if they're going to take this same approach to verbal presentations or not, but then I'll just defer to you then if you want Mr. Rumsey to comment any further on conditions.
I think it would be helpful to hear from him in relation to the monitoring suites and the parameters that he thinks would preferably be included in those monitoring suites.
Yeah, that's likely to be reasonably technical. Would it be suitable or satisfactory for you if we could get him to put that in writing for us?
Absolutely.
I don't want to run out of time to hear from the rest of your submitters who are sitting here patiently waiting to have their turn.
Yeah, no, absolutely. I mean, that's fine. We can do that.
And also, Mr. Rumsey, our procedure is that the verbal information you've been providing to us in response, I hope, to verbal evidence given during the hearing from the applicant's experts, you're to put that in writing for us. So that's what we're asking all of the other witnesses to do when they do what you've just done, which is verbal comments on things you've heard yourself. So we look forward to you documenting what you've been speaking about for the last 40 minutes to us about.
So I have documented this already, so it could be easily presented to you.
Yeah, sorry, I didn't quite hear what you said then.
I have written everything up
Oh, yeah, good.
already. So that could be to you Monday.
Yeah, no, that's fine, thank you.
So that concludes what I want to.
Yep, and so if you include your written comments on the conditions that you wish to speak to, that you were going to speak to, we look forward to receiving that as part of that further written information you're going to provide. And we will read that, so don't be concerned that we won't read it and have regard to it, we will do. In fact, it's probably easier for us to read it than to try and track what you're saying verbally and take notes, etc.
Yeah,
But
I
that's
did want
okay.
to rush into my evidence written to you beforehand before getting it this morning.
That would have been helpful. So we'll just see if we have questions for you, Jan. Any questions?
Just got a couple, thank you, and I'll make them very brief. Talking about the waste acceptance criteria, and you mentioned to us at the start that you had been involved in both AB Lime and Dome Valley consent processes, but not the final stage of Dome Valley. Have you reviewed the final Dome Valley conditions?
No, not the final. I saw some earlier ones when I was looking at AB Lime, but not since then, no.
Okay.
I had concerns about what it ended up being for Dome Valley.
But you haven't seen the final one, so that's all I needed to know.
Yes.
Along the way in your presentation, you briefly mentioned that putrescible waste, or the waste that comes into the landfill, can have a different effect on the liner. So just briefly, and feel free to add this to your notes when you send them in, what is the effect putrescible waste has on a liner?
The simple answer is very little.
So why did you make that point? Because there seems to be no point to the comment you made then. You were basically saying there's a danger to the liner because of the waste that comes in, and then mentioned putrescible waste. I'm just struggling to follow what your point is.
I wasn't trying to link those two statements together.
Right, okay.
I was trying to say the waste, it's important for the waste acceptance criteria to take into account what liner material is being used. And I think in my statement of evidence that you've already received, I give examples of aluminium processing waste. So if you would accept some stuff from Tiwai Point aluminium smelter, there is a potential for overheating events causing the liner to either reduce its service life or in a really, really worst case scenario, actually fail.
Right.
That was just an example, but I think that stuff is already covered in my main evidence.
That's fine. Thank you. I've got no other questions for you.
Mr. Ramsey, just three things. Just your paragraph 62 and your pre-circulated evidence. You got that there?
Going to page now.
And I'm just interested in the second to last line where you talk about remedial action that should be taken if trigger limits for liner temperatures are exceeded. What sort of remedial action would be required in your view?
It depends a little bit about what stage you're in, and you asked a very similar question to Mr. Kuhn, and so some of the answers are the same as what Mr. Kuhn said. You know, if you're partially filling a liner and you've got an over and you expect the liner break, you can dig out that material and place another part of the material into another part of the landfill. You may have to put down more extraction wells to get more leachate around there and actually make it a dry cell. Basically pump it dry and keep the leachate out of there that cell. If you've got a failure of the liner at that point. But as Mr. Coombs correctly said, if you've got a complete and utter failure of your liner, the liner itself, then there's not much you can do.
Oh, sorry, Mr. Ramsey, I'm not sure the paragraph that I've referred you to, 62, is talking about liner breaches. It's talking about trigger limits for temperatures.
Oh, for temperatures.
Yeah, that's the paragraph 62, what you talk about. Which I thought,
Sorry.
yeah. So the question again is if a trigger limit for liner temperature is set and monitored, and if a trigger limit's exceeded, what remedial action would be taken in response to that?
Actually, it's the same as what I've answered you.
Okay. Okay, that's easy.
Because what you're doing there is, I've got an overheated event, and what all the thermal monitoring is basically showing you is I've got a potential cell that could be failing sometime in the future. The liner will not hit its design life.
Yep.
So your options are stop filling it if it hasn't been filled, remove waste if you could,
Yep.
or pump it dry, continue to keep it a dry cell so there's no leachate that can escape through it when the liner did fail.
Yep.
So, yeah.
No, that's helpful, thank you. And take you to your paragraph 79. And your sentence at the top of page 28, landfill gas, this is your recommendation. Landfill gas in all operating extraction wells should not exceed 5% oxygen by volume. So just a couple of questions about that. So this is confirm my understanding and tell me if I got it wrong. So this is a fire prevention type of condition, is it? Is that what it's designed to address?
That's the primary reason. It does actually have other advantages in terms of making sure that the flare itself doesn't get too much residual nitrogen in the low flare events. But the primary reason for setting that is to avoid a subsurface fire.
Yeah. Okay. And so that would be measured by monitoring the landfill gas?
At the extraction point.
Yeah.
At the lookhead itself.
Yeah.
And that's a routine thing to do.
Yeah, yeah. Now, similar question to my earlier one. What would happen, in your opinion, if the 5% was exceeded? What would need to occur?
You just decrease the extraction rate of the well. It's just tuning of the system.
Okay.
If that didn't work, you'd start doing investigations. You know, do I have a leak around the well that's not properly sealed, it's just sucking air in? Do I have a landfill capping failure in the area? Then you might do an ISM, or, you know, one of those walkover surveys to sort of find out what's happening there. Or have I just placed this well in the wrong place, and you know, you've placed it too close to the working face, and then you just shut it off.
Yeah. Okay. Now, just a couple of questions on this issue of PFAS with an A, PFOS with an O, and PFOA. So now my understanding is that PFAS, PFAS, I mean, they're a very common group of chemicals, and PFOS and PFOA are subsets of PFAS, is that correct?
That is correct. PFAS is about 32,000 compounds.
Yeah, it's huge, isn't it? So PFOS, so the key concern there is that its use in firefighting foams.
No, that is incorrect. It was only less than 1% of all PFOS ever manufactured was ever used for firefighting foams. It was used, 3M used it a lot in Scotchguard. That was sprayed on fabrics, carpets, etc. Sofas, etc. I do actually have something from 3M which actually lists every single use that they used it for and the belt volumes, but it was used for a wide range of things. It was used for lipstick, it's used for dental floss. It was used for suntan lotions.
Yeah, no, that's good. That's good. All I need to know is much wider than firefighting foams.
Yeah.
Yeah, that's good. In terms of your concerns about the liner design for this particular site, can that be alleviated by conditions that, for example, might require detailed design to be subject to the peer review panel that's been suggested?
I believe it could be addressed through consenting, but I believe more consents than that conditions would be needed, like doing the fundamental risk assessment and agreeing to the service life of the engineering systems. You know, how long do they need to perform for? Is it 40 years, 60 years, 150 years? And then ensuring the design and the landfill management plan put in place the appropriate measures so that can be achieved. So, and I think for that you're going to need also that bioaccumulation, human health risk assessment.
Yeah, so is that a yes or a no then?
I believe it could be consentable. There will be a lot of consent conditions.
All right, thank you very much. That's the end of our questions for you. We look forward to receiving the write-up of your verbal discussion with us that you did earlier. So,
Thanks,
Ms. Irving,
Andrew.
next witness.
So the next witness is David Ife, and he is joining us from Australia via Zoom. Hopefully he's online.
You can hear me now?
Yes, I think so.
Okay, fine. I've had problems with Zoom in the past, so I just wanted to be sure. Okay, well, look, I have a few points that were raised in response to some of the issues that came up in evidence earlier in the week, so I'd just like to go through those.
Mr. Ife, just before you do,
Yep.
have you written those up, or are you just going to speak off the top of your head on those?
I have some dot points which I can provide.
Yeah, good.
Yeah. So, and just going through them, in Richard Coombs' evidence was talk about the baseliner and the sideliner, and there are different designs for the baseliner and the sideliner. And I think the sideliner, the proposal is to have a 600 millimetre clay with HDPE, but no GCL, no geosynthetic clay liner. And I think that is not a good option because his point was that most of the leachate is going to report to the base, onto the base liner. But in fact, with perching, our landfills are very heterogeneous medium, and with perching and so on, there's always the potential for migration of leachate laterally against the sideliner. So I would strongly advise that the same standards be applied for the sideliner and the baseliner, and that's in my evidence. Mr. Coombe also indicated that the groundwater interception drain the flow rates are going to be very small, and he quoted a number of 87 cubic metres per year. In fact, the number is from Mr. Kirk's evidence is 87 cubic metres per day, not per year. I think Ms. Cornter asked a question of Mr. Coombe and also of Mr. Kirk as to how long leachate would take to migrate from the landfill to the groundwater system. And I think Mr. Coombe said a long time. I think Mr. Kirk said many years. I think this point about this is that there is another pathway for this movement to groundwater, and that is through the the subliner drainage system. And this system is immediately below the liner and is designed to relieve upward groundwater pressure to prevent heave and so on at the base of the landfill. And this system would be a pathway for any leachate migration in that area of the cell where you have this under drain with groundwater in it. That would provide a pathway to the external environment, and that would occur over a much shorter time frame than the many years that Mr. Kirk indicated. So they were my comments on Mr. Coombe. Mr. Kirk indicated that my calculations of PFOS impacts on groundwater quality did not take account of mixing, which I found strange because actually that's not what it was about, and I gave the formula in my statement, so we can see that. So it is a mixing formula. And I think also should be pointed out that dilution is not a solution to pollution, as we all know, and whether it's mixing or not, there's still an impact. And when you look at PFOS, the calculation that I've made indicates that it exceeds the ecosystem protection level when you do that calculation. Mr. Kirk also said that the hydraulic gradient to the groundwater system is always downward. That's true over most of the landfill footprint, but when you get down to the lower slopes, and when you look at Mr. Kirk's hydrogeological cross-sections, you'll see that the groundwater levels in the deep and shallow aquifer are almost equal. So at the lower slopes, there's no hydraulic gradient downward, and in fact, at the base of in the creek, that's actually a groundwater dependent ecosystem, like groundwater flows into the creek. That's what the hydrogeological section seems to suggest to me. So, and that's of course the reason why you have the groundwater under drain, because you have that groundwater system underneath the liner. So it's not totally true to say that the hydraulic gradient is always downwards. Mr. Kirk also raised the issue of potability, indicating that potability relies on yield as well as water quality. That is true when you're talking about water for drinking purposes, if you pump it from a well for a drinking water supply, and I'm not suggesting that might occur immediately adjacent to the site, although it's quite possible that it could. But the other point about the water quality, groundwater quality, is that, as I said before, it's a connected groundwater system. So the groundwater emerges at the base of the valley and flows into the watercourse. So because it's classified as potable, it's a high quality groundwater, and that quality, if that gets degraded at the groundwater, then that'll impact on the surface water system. So I make that point about water quality generally and the issue of potability. Now, I know there's been a lot of discussion with Mr. Rumsby and Mr. Kirk on trend analysis and so on, and heaven forbid that I should go into that discussion any further, but I'm going to just for a minute. To my way of thinking, we're talking about two different things. I think we're talking about the background water quality, and the proposal is to have, I think, 3 years of groundwater monitoring data, or monitoring data before the facility's actually constructed, and that this will provide a basis for, to my way of thinking, that's going to provide a basis for assigning water quality to background. So you'll be able to understand from that monitoring record, and there'll be peaks and troughs and so on, but that will provide an indication of what the background groundwater quality is. So that's where the trend analysis comes in. You can use a trend analysis to assign a specific number to a particular analyte, if you like, in the background. Trigger levels is a different thing. A trigger level is a set level coming out of the guidelines, so ANZAC guidelines or the NEPM guidelines, and they are for specific parameters. They are levels which mustn't be exceeded, and so it's nothing to do with the trend analysis. To my way of thinking, they're just a set level, and when in my jurisdiction here, when we report monitoring for landfills to the EPA, monitoring records, you need to point out where there's been an exceedance, say in an ammonia level, which might be indicative of leachate impacts. So you need to highlight that and say, well, this is an exceedance and that needs to be recognised. Now, whether a single point becomes an issue is that can be determined over time with more records, but the trigger level is a set level for the water quality criteria. Excuse me. The final issues that I'd like to talk about are regarding LERS and its suitability as a construction material, and I think this is a bit of a sleeper in the context of this application. Construction of a landfill relies pretty heavily on the suitability of the local materials. You don't want to be importing large volumes of clay or whatever. And I think that the testing that Samantha Webb's carried out suggests that there is a range of permeabilities, and there's also a dispersivity issue. And I accept her evidence that can be addressed through treatment with lime and bentonite. But there seems to be an issue with plasticity, which I think from her evidence, it doesn't seem to be totally addressed. I think she seemed to me to be a little ambivalent about whether they were going to meet criteria for plasticity. And plasticity is very important when you're constructing a liner, because the advantage of compacted clay liner is it does provide movement, flexibility, and in an issue that may be subject to particularly seismic impacts, but also differential settlement and all of those sort of issues. You need to have that. You need to have that plasticity. You need to have that flexibility. So I think it's an important consideration, and there needs to be more. Obviously, there will need to be more testing to see that that's going to meet the standard. She indicates that a pug mill will be used to achieve the correct characteristics for when you're mixing, say, lime with the LERS, you've got a pug mill's a good way to do that. And she indicates that would meet QC requirements. And I suppose that sort of begs the question that we haven't seen much in this application on the QA/QC requirements for the construction, and particularly for the landfill liner. And that's an important part of an application. It should be there should be a standard procedure for conducting QA/QC testing on the clay liner. So they're the points that I raised in response to the issues raised earlier, and I'm happy to address questions and talk to questions.
Thank you very much for that, and we look forward to getting your written bullet points on those matters. Questions? No. Jan, questions?
Just got a couple of questions. One of them comes out of the point you made about the pathway for leachate drainage, and you said that if you were going through the sub-drainage system, then it would be a shorter time frame, but you didn't sort of hint at what that might be. What would that be? Just approximately?
I would say within a year. So you'd be monitoring the water quality of the groundwater coming out of the underdrain, and certainly it'll be months rather than years. Certainly within a year, you would see evidence of a leak.
Thank you. Now, I've just got a few questions on your written evidence. So have you got that on your screen somewhere?
I do, yes.
Paragraph 64. I don't know that I need to ask this, but I'll just carry on anyway, and I'm sure the chair will beat me on the head if I ask a question I'm not supposed to ask you. You're talking here about BPEM and what it indicates a liner system should comprise, and you've made some comments about all of that today. The first question is for you on liners, and I raised this with Mr. Coombe the other day, that my own experience in my professional life is that the liners are traditionally specified in consent conditions, so there can be no doubt about what's coming and who's expected to enforce that. Is that the same experience in Australia?
Yes, it is. Yes, exactly. It's part of the licence condition. Yes.
And your BPEM, I completely understand the point you're making, but I suppose my question is, here there's been the reference to the Wasteman's guidelines. Mr. Rumsby's just pointed out that in his view they are simply guidelines. When I read them the other day, I noticed they were prepared by a number of very experienced professionals in New Zealand, and that does seem to be the purpose of them, is to assist with landfill design and development in this country. So are you aware of any substantial differences between BPEM and the Wasteman's guidelines?
No, I don't. No, I'm not aware of any substantial differences. I think one of the things that the Wasteman's does is it has a lower standard for permeability. With the Type 2 liner, they have a 10 to the minus 8 metre per second clay with a 600 millimetre thickness, but overlain by a HDPE and a GCL. The BEPM standard is generally goes more to a metre thick compacted clay liner and a 10 to the minus 9 metre per second permeability. But they do talk about this 10 litre per hectare per day, so they have a design objective rather than try to be too prescriptive, and that's probably more relevant for the cap than the basal liner, because there are alternative caps that you can put onto a landfill rather than having a designated permeability. But provided they achieve the same litre per hectare per day flow rate. So yes, there are some differences in that 10 to the minus 8 and 600 millimetre. That's BEPM is a bit more stringent than that.
Okay. Now, you've already answered the question I had about Ms. Webb's evidence, so I don't need to ask you that. The final question I've got is, in your paragraph 98, you refer to Mr. Dale's conditions, but the date the landfill management plan it was, 4 June 2021. He's in fact developed that further, and a lot of this was attached to his evidence, and I just wasn't sure if you'd seen that.
No, I haven't seen that.
Okay.
But I'm glad that's the case, because the June 2021 document was fairly inadequate, or quite inadequate actually.
Yeah, well, it's come on quite a long way in that
Okay.
year or so.
Yeah.
So you haven't seen that, okay?
No, I'm sorry I haven't.
No, that's fine, no problem. I'll leave it there. Thank you very much.
Mm-hmm.
So just a couple of questions and then a couple of comments. I'll deal with the questions first. In terms of your paragraph 63 and the liner issue, obviously with any landfill, the integrity of the liner is crucial. Can an approach be used here whereby, say, conditions could specify a necessary permeability to be achieved by the liner, with the detailed design of achieving that then being subject to the review of the peer review panel? Could that kind of approach work here?
Yes, I think yes, it could. Yeah. I think permeability and thickness, I would say,
Okay.
for the compacted clay.
Yeah. Would it be within the domain of your expertise to craft some words in that regard for us to look at?
Yes, sure. Yep.
Would you be happy to do that for us, or just be
I'd be
interested?
happy to do that. Yep, I can send that back with my other notes. Yep.
Yeah, and that can just feed into the mix, and then I'm sure we'll get responses to that from the council officers and the applicant in due course.
Okay, so you're looking like for a specification of what?
Yeah, I guess what I'm thinking of is specifying an outcome that's to be achieved by the liner, whether it's permeability and or thickness or something else, and then leaving the achievement of that to detailed design, and that detailed design then being reviewed by a peer review panel. I'm just thinking aloud in terms of some kind of process like that to make sure, or that would give us confidence that the liner is going to do the job, really.
Yeah, absolutely. Yeah, sure.
Yeah. If you're happy to help us with that, I'd appreciate that.
Yeah.
And just one more from your evidence. Your paragraph 86, have you got that there?
Yep.
So I can't remember, micrograms per litre, is that parts per billion or parts per million?
No, it's parts per billion.
Yeah,
Yep.
so, yep.
Yeah, milligrams per litre is parts per million.
Yeah. And the 99% ecosystem species protection value guideline you quote there, what's that from? Just remind me whether you've got that from. What guideline document did that come from?
That's from the NEPM, I think, but I would defer to Andrew on that one. I think Andrew Rumsby.
Well, why don't you just, if necessary, confer and then just pop the answer to that in the written material
sure.
you're going to give us. That's fine.
Yeah.
Now, in terms of, and these aren't really questions, but in terms of the issue you raised about the low S and diverse dispersivity and plasticity, I'm not sure if you heard yesterday not yesterday, the day before, we're hearing from Samantha Webb. I think I asked her to come up with a condition whereby further testing would be done as she recommended, and for her to think about a condition that would say if the testing didn't yield a certain result, then low S would not be suitable for use in the liner. So it's like a stop, don't go any further type condition. Do you see that being a workable solution to your concern?
Yes, it would be, yes. Yeah. It sort of does beg the question, well, what would they do? Where would it come from? A suitable material, but yes, I'd agree with that. Yes.
Yeah, and of course, if the low S wasn't suitable, then that would be a problem for the applicant or the consent holder at that stage, should consent be granted to deal with, rather than us to get unnecessarily concerned about.
Yeah.
And then another comment, just I'm not sure if you heard my questions of Mr. Kirk about trend analysis, because I was initially confused by that, and my understanding is the same as yours, that normally a 36 months sampling period, and the analysis of that result is used to quantify background conditions, but then discharge or receiving environment standards derived from appropriate guidelines. So
exactly, yes. And two separate things, yeah.
Two separate things, and that's my understanding and experience as well. hence my questions to Mr Kirk. All right, but no, thank you very much for your evidence, and we look forward to the further assistance you're going to give us in terms of that written material.
Okay, no problem. Thank you.
Thank you.
Thank you, David. Do you want box on? 10 to 12. Mr Lloyd is next, so
Yeah.
I suspect we will get through.
Does anyone want a 5-minute break? Are you happy to box on? It's been reasonably turgid.
Yeah, maybe just 5 minutes to stretch legs, maybe.
Given the matters we've been dealing with what I might colloquially call reasonably turgid, we might just take a 5-minute break and we'll hear from Mr Lloyd after that, if that's okay with you.
Absolutely.
Now, just I'm not sure timing-wise and how long your other witnesses intended to speak to us verbally about their written submissions and their written evidence. So I don't know if you have an idea of that, but if we do, we must finish at 3 o'clock so we can catch our planes home, presuming they're still going to fly given the windy conditions elsewhere in the country. But putting that to one side, if we don't get through all of your witnesses today, we do have time available on Tuesday next week should that occur, but again I'm not sure how that's going to play out, but maybe that's something to think about over lunch.
What I'll try and do is just gather up. I know people have made a few notes, but generally very brief.
Yeah, that's good.
Rumsby was our wildcard.
Yeah.
And so I think we probably will barrel through reasonably quickly, obviously depending on the questions that you have.
Yeah.
But I'd certainly expect things to speed up a bit once we're through the experts.
No, that's fine. And we can always take a shorter lunch, 45 minutes instead of an hour or something. So, okay, that's good. Right, so we'll just adjourn for 5 minutes, stretch your legs. Remember, if you get up and walk around, put your mask on. And we'll see you back here in 5 minutes or so. All right, everyone, we've had a little break, so now we'll resume the hearing. Ms. Irving, back to you.
Yes, I'll now call Calvin Lloyd.
Good morning, Mr. Lloyd. I think you understand the procedure we've been running whereby you read your evidence. Thank you very much for that. If you wish to respond verbally to matters that have arisen from the applicant's experts during the hearing, then you're welcome to do so now. Otherwise, we can just go to questions, but over to you.
Yes, thank you for that. And there are just a couple of issues.
Sorry, I'm not sure if is the microphone on for you?
Okay.
Yeah, much better,
That's
thank
better. You. Yes, thank you. And there are just a couple of issues raised that I'd like to respond to.
Yep.
I wasn't able to attend the hearing prior to today, either remotely or here, so I've only really seen those responses this morning in a tabulated document, so I haven't had time to provide a written response, but I can do that.
Yep, that's fine, thanks.
So firstly, I'd like to respond to the further evidence of Ms. Blakely and Ms. Sibright, who concluded that effects on freshwater values and birds that might be feeding in the freshwater environment would be absent outside the immediately affected area. And I can kind of understand why they haven't assessed further effects, because I myself was quite alarmed when I read Mr. Rumsby's evidence, and I've looked at literature on PFAS substances and their accumulation in the environment, and it's a fairly recent and emerging issue. There are numerous papers on it published just 2020, 2021, and they're not, the detail isn't fully settled yet, but there are some broad conclusions that can be drawn from that evidence. And we do have, in my opinion, a receiving environment in Otokia Creek that is potentially vulnerable to release of PFAS substances into the creek. So firstly, landfill leachate has been identified as a common release point for PFAS substances. I acknowledge that PFAS substances are numerous, and what research has shown that not all of them are bioaccumulative, but some of them are. And I don't have expertise as a biochemist to go any further than that. What is known is that in the freshwater environment, crustaceans are particularly susceptible to ingesting PFAS substances, and they are also more vulnerable to the toxic effects of PFAS substances. Freshwater vertebrates, fish, they can accumulate high levels of PFAS substances because they feed on crustaceans, but freshwater fish have been shown to be in general less susceptible to the toxic effects of PFAS substances. But if we go one step further in the food chain, air-breathing vertebrates show greater toxic responses to PFAS substances. So in Otokia Creek we have abundant crustaceans. We have eels. That a major food item for eels is crustaceans, so there's a pathway for movement of any PFAS that crustaceans consume into eels. I'm aware that both koura and tuna eels are significant mahe kakai for mana whenua, so consumption of eels by humans can result in toxic effects in human populations, and quite a bit of the scientific literature is on those effects. But also there are birds such as kotuku, the white heron, black shag, who will feed on koura and eels out of Otokia Creek. And as air-breathing vertebrates, they could potentially accumulate toxic levels of PFAS should it be released. There haven't been many studies in New Zealand of PFAS accumulation in indigenous species, but there has been a study of common dolphins in New Zealand, and it's been shown that they have accumulated PFAS or PFAS substances. So there does appear to be a clear risk of toxic ecological and human effects of PFAS consumption, based on a scenario that the controls on the proposed landfill don't fully work and allow PFAS substances to escape into Otokia Creek. So that is the basis for my disagreement with Ms. Sibright and Ms. Blakely. And I just want to comment on Dr. Morris's comments about the wetland, and if there's a loss of water supply, there may be invasion of weeds into it or dryland species into it. And he agreed with my evidence that could occur, but he stated that weeding could resolve that issue if it did occur. It may not be always practical for weeding to resolve issues such as dryland species invading wetlands, because those species will include grasses, rushes, sedges, woody weeds, and some of those can be quite hard to control if they invade into a wetland. I'd consider the marsh wetland to be most vulnerable because it is by definition a drier type of wetland. It has a fluctuating water level, and sometimes there's no water at the surface at all. So marsh wetlands tend to be already invaded by dryland species, and at the site there's gorse, for example, in that wetland. And so they are quite vulnerable to any further drying out. There's a lot of pressure on them from terrestrial plants trying to invade, and it's only the wetness that is keeping those other plants out. Those are the only two issues that I wanted to raise.
Thank you very much for that. I'll see if we have questions for you. Jan, any questions?
Not from me, thank you.
And Ross?
Thank you, Mr. Lloyd. My question relates to some of the criticism that you included in your submission around the methodology used by the applicant's experts. And I was just wanting to, I guess, hear your views on how you arrived at that view. We've heard consistently from the applicant's evidence, and also I think the ORC experts agree that it is an accepted and well-used approach, which is objective, yet you've said that the approach is subjective. So I was just really interested to kind of, I guess, understand a little bit more where you're coming from.
Yeah, sure. The key element, you're referring to the EIA-NZ
Yes,
framework for
correct.
assessment of effects. So the key element where it is subjective is where the assessor initially assigns a value to the Indigenous biota that's being assessed. And that then flows through the rest of the framework. So once that value is assigned, a level of effect will be assigned on that, and then an overall level of effect. So that's a fundamental part of the assessment, and I've seen a lot of variation when people use that framework and what they consider a low, medium or high effect. Sometimes I've seen, one of the recent Oceania Gold consents, there was a moderate or high level effect assigned to 2 non-threatened plant species, but a whole lot of nationally at-risk species weren't assessed as they were assessed as being of low value. And I was part of the acting for councils helping to audit that application, and through that process all of those species became included as higher value species. So I've seen a lot of variation at that step, and it influences the rest of the assessment. So I don't accept that it's a fully objective process, and that would be a very hard thing to achieve in any case. Other aspects of it, at the end, there's a table that derives an overall level of effect, and it combines level of value with level of effect. But the way it does that is not logically consistent. Sometimes it's an additive outcome you get, sometimes it's a zero-sum outcome. And it seems quite arbitrary to me, so not robust, in that I can't see how that matrix, I can't see the logic in it. The other aspect I find is that the EIA-NZ approach puts a lot of large tables through reporting, and I find it adds length and complexity that isn't really required. And finally, it tries to establish a nationally consistent basis for assessment of effects and values, but every district has slightly different ecological significance criteria. So I would always go to the statutory policies as the basis for my assessments, and I don't need the EIA-NZ framework. And it's not fully objective, and it has some disadvantages, so I certainly don't use it.
Oh, thank you for that. I think you've, in the process of answering, you've answered my follow-up question, which is what would you use as an alternative, and so you've mentioned that you'd use the statutory policy guidance for that.
Yeah.
Thank you.
And thank you, no further questions from me, but thank you for your evidence, and we look forward to, if you're going to provide any further little notes in terms of the verbal presentation, that would be appreciated. Thanks.
Thank you.
All right. So I'll now ask Sarah Ramsey to come up, please. Yeah.
So yes, good morning and welcome. You've provided a written statement of evidence, I think, which we've read, so you don't need to read that out to us, but you're very welcome to highlight key points, or else if you prefer we can just go straight to questions, or if you've got something to show us on the screen, then proceed with that.
Thank you. I have prepared a few words, but I promise it is brief. And I think the photos that we've prepared on the screen actually speak for themselves, and that top right photo there is actually my husband Alex and my son Finn fishing for kura in the upper catchment of the Odour. So I hope that my evidence was able to express to you the value of our off-grid slice of forest has to us. That we value our native plants and our native bird life. We live, we play, and we conserve our environment on a daily basis. It is completely unimaginable to my husband and I that our 6-year-old son, who wakes up at 7 a.m. and goes to bed at 7 p.m, will do so 7 days a week to the sound of a major industrial landfill operation next door. And we will hear it. We can clearly hear people talking on Big Stone Road, perimeter of the proposed landfill, 1 kilometre away. When harvesting of the trees is happening, we hear the beep, beep, beep of the forestry excavators when they're in operation some 2 kilometres down Big Stone Road, but they don't operate in the weekends. Not to mention the smell. On a good day, it is completely still. I understand this is when the smell is most likely to affect us. On the best summer days, when there is no breeze to disperse it, and we're outside in the garden. For my family, of course, we are the ultimate not in my backyard NIMBYs. But to be honest, if it were just that, my husband and I would have given up long ago and just sold up. Because we do feel like idiots. It is mortifying sitting here feeling fully the naive and foolish people we were when we bought our house 11 years ago and didn't get the right advice to investigate beyond the LIM report. This isn't just a NIMBY campaign for us. It's not just my family's backyard that's at risk. It's our school, our beach, our weekend exploration of the creek, and our incredible community clubs. It's our community's mana that is at threat. I am so angry. I'm so angry. First at myself for being such a moron that we've found ourselves in this situation, and secondly at the council, who've had every opportunity to manage their designation and planning better. They simply have no excuse. And it's this failure to properly manage their designation that points to their poor management track record. They have had every opportunity to prevent our and neighbouring residential developments by, at the bare minimum, including the designation on our LIM. I am not an expert at anything remotely scientific, but I am considered to be an expert in management. I know that good design and strategy mean nothing in lieu of excellent planning and, most importantly, the capability to execute. The DCC's landfill management plan and the application itself was incomplete. It's being iterated throughout this process. What we have now is quite different to what was submitted initially. They've had this designation to prepare for 30 years. Can we expect this poor management to continue throughout their operation? And the business of a landfill is significant. This one's budget is $50 million. In Dunedin terms, that's an incredible project. In the business of a landfill, surely good planning starts with siting, a site that, even if the chance is remote, has major risk to human life and catastrophic permanent impacts on a sensitive ecological and social environment. Surely it would not pass today's standards. 30 years ago, there were no residential neighbours. The airport wasn't consulted, and as a society, we didn't have the environmental knowledge that we now have. The experts on all sides over the last few days have said there is a risk. They may disagree on the level of risk, but we all agree if there is a fire or a failure of the liner due to the earthquake, failure to manage to the conditions, or an extreme weather event, for example, that it's got the potential to destroy our sensitive environment and our community. In the case of my family, immediate neighbours to the site, if there is a fire that coincides with a nor'westerly, we literally will not have time to escape. You've heard from hundreds of neighbours and community members from Brighton that if this landfill goes ahead, they will avoid the creek for fear of what may be in it. As far as I and my fellow parents are concerned, the only safe option is no risk. You will hear evidence from David Grant, principal of our school, that they will avoid our creek for learning opportunities with our tamariki, for fear of what could be in it. It is because of this fear that we ourselves as a community have fundraised over $20,000 to pay experts and lawyers to represent us, and on top of that, Alex and I have personally taken out a mortgage on our house to fund it. It was money well spent. David Ife, Andrew Rumsby and Calvin Lloyd have all submitted compelling evidence to the contrary of DCC that yes, there is risk, to both the environment and human health, and it is significant. As a community, we feel under siege. We don't trust the DCC, and they've done absolutely nothing to alleviate that fear. Their total unwillingness to engage in meaningful consultation with our community is arrogant at best, and it's outright bullying at worst. Without trust, we cannot be confident that the DCC will look after us. Without confidence, we have doubt, and with doubt, we have fear. And when we fear things, we avoid them, and therein lies the problem. If the landfill goes ahead, even with the 115 conditions imposed, if we do not trust the council to operate it, then the perceived risk will still have a devastating impact on our community. Imagine a special community like Brighton being destroyed simply because we don't trust our water. Isn't that a basic human right? That our families are safe, playing in and eating from our creek? That is my statement. Thank you.
And thank you very much for that. See if we have questions. Rose, any questions?
Thank you, Ms Ramsey. I appreciate and acknowledge the situation that you're in and what you're experiencing. So thank you very much for taking the time and for talking us through your concerns and worries around this proposal. We really appreciate it, and we need the experiences of residents to help us understand. So thank you. I had one question for you. I'm not sure whether you've been able to keep up with or hear the evidence of Mr Henderson earlier in the week regarding the operational hours of the landfill.
I haven't, but when we were initially consulted, Alex and I, we had a meeting with Chris, and he did say in that meeting that they could manage noise by making sure the landfill didn't operate on the weekends. And so I was very surprised to see in the submission that they've actually put that through from 7 till 7 days a week.
Right. I think from my memory, they've put forward a proposal to amend the hours from 7 to 7 to 8 a.m. to 6 p.m. And that would be Monday through Sunday. And I was wondering whether that went any way to alleviating some concern that you may have.
It's the weekends that we are most concerned about.
Okay, all right, thank you.
Thank you also from me for your evidence and for taking the time to put all this together. You made a comment about the landfill management plan, and I just want, this is not so much a question quite, but just me making a point here to help you all with this, if Ms Irving hasn't done it already. It's quite common for landfill management plans to sort of develop along the way. Part of the reason for that is because as issues arise or conditions are discussed, the two things almost need to mirror each other, and, well, not mirror each other, but there's a process of conditions and management plan drafting that goes on. So the process that's occurred here, where there has been a draft, is in fact assisted us to some extent to see how that management plan might look. And now we have another version that looks quite different, and I completely accept that. And for all of you, you probably don't want to be sitting there till midnight reading all of those things. But they are often then not finalised until much later, because they have to kind of reflect what the conditions say if the consent is granted at all. Part of our exercise is to figure out whether the conditions in the management plan do what the applicant is suggesting and do actually mitigate effects and so on. So we're just working our way through that. That's why there's so many questions from us on all of that. Just to assist me, because we did go out to the site on Monday, but I have omitted to bring with me today the map we had that showed where all of you are. Mm-hmm. Would you mind just describing for me? So we came up from the State Highway up to the landfill where the entrance would be, and then we came out again.
McLaren Gully Road.
Yeah, and then we went over to Brighton. So where are you in there?
So if you came up McLaren Gully Road and then turned right, we're the first driveway on the left. So right. we're directly opposite the landfill.
Oh, okay, right, yeah, got you. Do you see into the landfill site?
Yes. Not from our house, but from our
from
driveway.
Driveway, yeah, okay. All right. No, the rest of it I understand. That's why there's no more questions. Thank you very much.
Thank you for taking the time to explain.
Oh, you're welcome.
And no further questions from me. Your evidence was very clear. I particularly appreciated your paragraph 65, where you very clearly set out your expectations for conditions should consent be granted. That kind of detail and clarity is always helpful, so thank you.
Thank you.
The next witness I'm intending to call is Blair Judd. Do you want to take him now or
Well,
break
see, we have
lunch?
no idea how long Mr. Judd might be. Do you have any idea on that?
I think a few minutes. Yeah, 10 minutes max.
Oh, sorry, I couldn't hear you.
10 minutes max.
Oh, that'd be perfect. So, Mr. Judd, we can hear from Mr. Judd, and then we can break for probably a shortened lunchtime. I'm thinking 45 minutes at this stage.
Good afternoon.
Afternoon.
Happy to go ahead. So I'm here in my personal capacity as a near resident as well as Sarah. We're two ridges over effectively, so 2 Ks as the crow flies. I'm also here as a representative of the South Coast Neighbourhood Society. With respect to my personal submissions, obviously I'm not going to rehash that, that'll take too long. I just want to note on a personal basis that I feel let down by the Council's lack of consultation on this proposal, especially given our proximity to the site. We didn't hear anything, nothing in our limb. It's, I mean, we're not next door, but we'll certainly feel the effects. And also with the community as a whole, as it's sort of been disregarded as being too remote to Brighton to be really considered to any great extent by the council with respect to this proposal. I've not been a party to RMA proceedings before. However, the nature of the application, and you elaborated on this a bit before, the backwards and forwards between the ORC and the DCC and the opposing views on earthquake risk, leachate risk, downstream effects, fire risk, and the completeness as an application as a whole, it's just left me frustrated with how to even approach making submissions. I don't do this for a living. It's hard to go through all that information and then respond, especially when that information changes day to day. I feel that given the constantly changing and adapting position this proposal and this process has been through, it's been impossible for me to assess the effects this proposal will have on a personal basis and for my family, and then adequately respond. So that's my personal view. Now, moving to the South Coast Neighbourhood Society, you've got my submissions and my brief of evidence. Again, I won't go through that, but I would like to address some of the points raised in the previous evidence on the last few days in the oral submissions. And I do also want to just re-emphasise the effect the landfill, if approved, will have on everyone in our community. We swim, and our children swim in the creek and the beach. We fish, gather and eat kai moana from the creek and from the immediately coast below it. We use the hills surrounding the proposed landfill for biking, riding horses, walking dogs and generally exploring and enjoying nature. All of this is at risk if this application is approved. With this at stake, the community is extremely concerned that a landfill and all the requirements that go into a modern landfill are not shoehorned into an old designation and siting, which appears not to be suitable in this day and age, and if submitted just 3 days later would be treated much more differently under much more stringent criteria. Now, turning to the points I raised in my evidence, with respect to leachate, I've had the opportunity to listen to some of the evidence given over the last week and peruse the evidence from the experts for our submissions. And from what I can gather, I understand there's going to be varying low amounts of seepage from the membrane. I don't know exactly what makeup that will be. It's obviously a dump, so it's going to have pretty much anything in it from my understanding. With respect to that leachate, as a community, we're particularly concerned with these pollutants that stick around and build up. Now, I've heard evidence this morning on PFOS or whatever. I have experience with that as a firefighter. We've pulled it off our shelves. I trained in the stuff at our training. They've removed that. There's so many regulations around it now, it's not funny. So, you know, I understand a little bit, but not a lot. And these chemicals aren't good, and we don't want them in our environment. From listening to the experts on liners for these types of landfills, I understand the liners will break down. It's just a matter of when, not if. 10 years has been indicated by our submissions, 150 years on the other side of the table. So many factors feed into that. I don't see any clarity around that, and certainly if that liner is the primary thing stopping that stuff getting into our rivers and creeks, shouldn't we have some more solid foundation around that? We don't even understand what the liner is going to be at this stage. As a community, we are going to bear this risk. Not any of these experts that are giving evidence. We will bear it. Our children will bear it. The council's had ample opportunity to address this risk, and they still haven't. If the liner does not perform, at least mostly as the council says, and fails when the landfill's active life is over, we'll still bear this risk. The contaminants, especially these PFOS ones as I understand it, will still be there. This isn't a legacy we want to leave our children. Now, moving on to the discussion of odours. We're not so far from this landfill that this won't affect us. I have heard and read the evidence on the Green Island landfill and the testing and stuff done around the odours there. It seems to be that the primary gathering of evidence is around complaints there. I would submit that a complaint is made when a smell is so putrid and horrible that it's unbearable. Passing odours happen all the time coming from a landfill. In my personal evidence, I noted that we could smell it going past Wardrenville. We could smell it. It was without a doubt we knew where it was coming from. Just because we didn't make a complaint, does that make that not a valid concern? I think that has been grossly underestimated on the distance that smell will travel, especially with the predominant wind coming over those hills, being westerly, nor'wester is the ones that blow over our place, and that's coming straight from the landfill. The only way I feel this could be adequately addressed, if it is even to go ahead, is that we exclude all organic waste from it, household and other perishable, as we call it, waste, which will give off those smells. I understand the dump takes stuff from the sewage treatment plant, it takes offal, it takes all other things. I don't know if even this stuff's been addressed. I know we're going to have a flash new bin system which will separate out our waste, but what's going on beyond that, whether that has even been considered or whether they're just relying on the goodwill of our community, which at times they have other concerns, might just throw it in the red bin. So finally, and the last one, which I do actually have some experience on, is the fire risk. I've read the evidence and I've listened to the oral submissions from Anthony Dixon and Paul Demir, and I'd like to just address a couple of their points. Firstly, with respect to ember transfer. I do note the measures indicated in the conditions will mitigate this to some extent. Having that 300 square metres certainly will mitigate that risk of those surface fires. Probably not so much with respect to the subterranean ones, and they're probably the bigger risk, I would submit. But with respect to those surface fires, Fire and Emergency, in conjunction with major forestry operators and companies, carry out risk plans around these forest areas. These plans build a 1 kilometre fire margin around all major forestry blocks, and this is to mitigate risk from fires. It's not a complete ban on fires, it's looking at peak days and it's looking at permits. So whoever is going to undertake or do a controlled burn in that area will have to go talk to the council, will have to go past the forestry blocks and tell them what they're doing so they can put mitigation measures in place and prevent anything happening. I do understand they intend to have a tanker with a water cannon effectively on it, and that will go some way to mitigating certainly the forestry's concerns on that side. But on those peak days where just as little as an ember could cause a fire, I do take it as mitigated somewhat. The forestry operations in the surrounding areas, they don't even work. They drop tools, they go and man the local tankers and brigades there, they have standby equipment there. They don't work on those days. They put down the chainsaws, they put down the heavy equipment, and they wait and are prepared to respond to fires. I'd submit that it wouldn't be unreasonable, if it is to go ahead at all, that the council in the dump would do the same and not operate on those high fire peak days. And that's anywhere from the experts' evidence from 4 or 5 days a year, at maximum 20 days a year, but certainly that would go a long way to mitigating that risk, certainly from the surface fire part of things. Now, with respect to the deep-seated fires, which has come up in evidence by, in particular, Odour, and also from our expert evidence in the briefs of evidence, I've attended these in my role as a firefighter, both at dumps and composting facilities. They're incredibly hard to put out. They take a hell of a lot of water. It's not uncommon for water tankers to be running 24/7, supplying, if you can reach it, and that's if you can reach it, a fire truck with water, and you're putting through thousands of litres a minute. So with respect to that, the 400,000 litres of water, it is good for surface fires, but with respect to subterranean fires, it won't be enough, and it could never be expected that there'd be enough to put out a fire of this sort with just on-site equipment. But what it does lead into is a couple of questions around how they would contain that water flowing from it, because to deal with a fire like this, you need to get to the seat of the fire. A lot of the water is effectively trying to get there but won't reach it. So it's going to penetrate every part of the dump. The dump will have to be dug up. There will be, it could be metres down, I don't know, I read somewhere they're talking 10, 15 metres depth in this dump. It's going to be a horrible job, and I'll be at it. But regardless of that, that's part of my job. I'm more concerned about what's happening to that water afterwards. We could be putting millions of litres of water. If something like happened in, I think it was Andrew Ramsby's brief of evidence, if something happened like up in the Waikato where they had a fire burning for months in their landfill, not to mention the odours, the toxic fumes and stuff coming from that as well, but just simply the water, because that's the catchment that's leading into Brighton. So, with respect to that, that's probably my major concern with those deep-seated fires. It's going to be a messy job, but that's what we do. And finally, just touching on the condition that's been discussed about lithium-ion batteries, it doesn't take a big one to start a fire. We've had rubbish trucks catch on fire with the compressors compressing as little as, and of course there's never a definitive cause, but you can lead to it through the fire investigation side, but as little as batteries from power tools. So to remove all of that from the waste stream, I know it would be incredibly difficult, but I think to limit that fire risk, because these fires don't necessarily occur on the surface, to limit the risk from those, it would be good to have a condition that could certainly bar them from being admitted to the landfill as much as possible. So effectively, those are my main points in response, my concerns both as a community and personally. Do you have any other questions?
I'll just see if we do. Thank you, Mr. Judge. Any questions, Dan?
I just had, I found, I completely understand all the points in your evidence, but because you've highlighted the fire topic, I just wanted to ask you, given you're a local resident, are there any, or have there been any fires in the forests around there?
So, about a year and a half ago, a neighbour's generator caught fire, and this is the ridge between our place and the Ramsey's place. And so we could see it basically glowing on the horizon. We were lucky on that occasion that it wasn't a high sort of peak day. It was when we're running our generators, so it tends to be sort of, I think it was autumn or spring. And that could have gone badly. The sort of the fire water supplies were all tankered in. The local crews, so I work in town as a career firefighter, so I wasn't attending this fire. The local crews did an incredible job at actually managing to contain it, and we were ready to evacuate to our neighbours the next ridge over in case it had gone in the forestry, because even when it's a lower fire risk day, it still takes a lot for the water to penetrate through pine trees and actually eliminate the risk altogether. So if a fire does get in there, it could be catastrophic. There's thousands of hectares of forestry around there, and a lot of people live in there now. And I mean, my family's at risk for one, the Ramseys. It's not a insignificant concern, as the council would seek to sort of indicate.
And given your experience with fires, say in rural areas, particularly in high risk conditions, you weren't here earlier in the week, but just for your information, I used to live in Wanaka, so we had often high risk conditions and fires, and helicopters were brought in to assist with those. So is that the trend here too?
Yes, it is. So a lot of things can affect that. If we can attack it with ground crews, we do, but rural fires are dealt with a lot differently than I'd personally deal with a urban fire. You don't attack it head on. You limit, you try and limit its spread as much as possible, and then hopefully the weather conditions come into play, as is often the time that tends to break the back of it. I mean, you've seen it, what happened in Port Hills and recently in Odour. In that initial phase, if you can't control it very small, then it gets very big quick, and then you're left with mopping up. And there's a lot of trees there. Certainly, Nelson's probably a better example as far as what happened up there to what could happen around the landfill. Somebody asked, I can't remember who, there's been a lot of people this week, but we were asking about the travel time out from the closest station to the landfill site. Have you got any comment on that? So the closest station to the landfill site is a volunteer station in Brighton. During weekdays, and this is no disrespect to the station there, they have trouble manning it fully because people have to work. They do get crews there, and they would be the first responding. They're probably 10 to 15 minutes down the road. They carry limited water supplies, but I take on board that there's going to be 400,000 litres there. And I also take on board the fact that with deep-seated fires, it's going to be slow moving. It's going to take a long time. So personally, I don't think the distance is necessarily the concern here. It's more the type of fire, given the mitigation measures that have been put in place or suggested to be put in place.
So given that you aren't happy about the volume of water for the subterranean fires, what would you suggest would be a more appropriate volume?
If you want to put a fire out, you've got to get to it and you've got to put water on it. There's not really two ways about that. You have to find that ember that is there, otherwise you'll be dealing with it again. I can't propose a alternative in my experience with it.
That's right. I just thought I'd ask.
No,
That's fine.
Yeah.
Yeah. I've got no other questions for you. Thank you.
No, thank you.
Any questions? Mr. Judd, just 2 questions. You mentioned in your verbal presentation the harvesting of kaimoana, and you said from the creek and from the beach. I can understand harvesting kaimoana from the beach. Looks like nice clean water, and I'm sure there's lots of good fish out there, etc. But the creek?
I haven't personally harvested kaimoana, certainly kura and eels from the creek. In the past, I have enjoyed this in other places I've lived. As far as the creek goes, that's not my personal side, but as I said, I'm representing my community as well.
Sure. Okay. And you've mentioned in terms of fire risk what you described verbally as high peak days, and in your written evidence for the society you've mentioned high fire risk days.
Yep.
Either. How are they defined and notified? Is that something FENS does, or how does it work?
Yes, it is. So FENS has a fire risk matrix done on dew point and moisture and a number of things like that. I don't profess to understand it. All I know is that we get notified of it and we get put on basically red alert that we're going to have something. And this typically happens sort of January, February, March. Each year we'll get a number of these days, and it's well known. And I guess that's, I'm not sure if I mentioned it, but that's where my question goes on consultation with Fens and Forestry, whether that's actually been taken into account and been accounted for in the fire risk assessment.
Yeah.
Yeah.
And I think you said verbally, typically four to 5 times a year, high peak days, but then you went on to say some other number, which I didn't quite catch.
Yeah, sorry, that was coming from the evidence of one of the experts, and I can't remember which. He had a graph of the fire risk days in there, and it peaked at 20 in the last 10 years and down to sort of 4 or 5 recently.
Okay, so you were referring to that evidence rather than your own personal experience? Okay.
Personally, from my experiences, we do have approximately half a dozen a year in the last few years, yeah.
Right, thank you very much. It's very helpful. So I suggest we break now, I'm observing, and we reconvene at, let's say, 1:30, which is just over 45 minutes. Does that sound all right?
Yeah, I think so, thank you.
All right, so we'll adjourn now and reconvene at 1:30. 1:30. Thank you. Well, good afternoon, everyone. We'll resume the hearing, and Ms. Irving, just before we come back to you, just Mr. Garbutt, just dropping over a couple of curveballs your way, but we have been wondering, having reviewed the evidence and then again the evidence we've received today, whether we would be assisted by receiving a quantitative public health risk assessment in terms of potential discharges to the creek. So we haven't formed a view on that yet, but we do note that in other similar applications we have received that kind of evidence. So appreciate, I don't want you to respond now because obviously you need to consult, but if you could think about that and come back to us next week on certainly the applicant's view on that. And of course, there's a couple of options there that could be volunteered by yourself, or your, sorry, not you, but by the applicant, or else we could just commission a report. So just really like your view on that. And also from the reporting officers, Ms. Lennox, so in terms of your technical advisors, could you answer the same question for us early next week? Whether they feel in terms of assisting you, they would benefit from a quantitative public health risk assessment, with the focus being on potential discharges to the creek and then what happens to the creek water thereafter. So that would be the focus of that. So I thought it's fair that we just raise that now rather than drop it on you next week, give you time to think about that.
Thank you.
Just a second matter, just in terms of next week, Mr. Garbutt, you're currently on the schedule we've got down for a reply on Wednesday afternoon, which is absolutely fine if that's what you still wish to do, but we were just wondering if you had any chance to think about whether you might want to take some more time and do a more fulsome written reply, or whether you would wish to give some verbal reply on that afternoon. We're only asking because it just affects travel and flights and things as well. And again, if you can't answer that now, that's fine, but if you can, maybe let us know.
Or maybe carry on with the witnesses, and if we've got time this afternoon, we can address that at the end of today if we've got time. But
yeah, and even if you can come back to us on Monday, we have to come down here on
Yep.
Sunday night to be here Monday anyway, but
Yep.
it could just mean it might affect what we do.
bring it forward, yeah, sure.
Going forward, yeah.
Yep.
So thank you for that. About Ms. Irving, back to you.
Thank you, Commissioner. So the next witness for the submitter group is Karen Hanna. Good afternoon, Commissioners. I'm here to speak on behalf of the Brighton Surf Club.
Mm-hmm.
I'm a parent, well, I'm also a secretary, but obviously a parent supporter and also a community member of Brighton, and I look down onto Brighton Beach every day. We've got a beautiful beach, and we're lucky to have a great facility which was built in 2013. We're very proud of our facility because it involved the community. There was community consultation before that building was actually built, input from the community as to what facility was actually required, not just for the surf club, but as the community as a whole. So we're very proud of that, and the community was listened to in relation to their feedback. As a result of that facility, we have seen increased numbers in our membership. We've now got 140 members in our junior club, which is the biggest it's ever been. To the point that we are now having to consider increasing the footprint of our building because it's now getting too small and not fit for purpose for running the club. We've had to put temporary storage at the back of the club just for us to hold some of our club gear for our junior members, but we will need to consider more permanent options. But again, the outcome of the hearing and what's going to happen with the landfill is likely to have an impact on that. There is not only the impact, as I've referred to in my submissions, the actual effect of contamination of the water, but also the public perception of that landfill is to proceed. As I've said in my submissions, I believe the public perception will have an impact immediately and not just when the landfill, if it commences. We have a very busy beach in the summer, and as you can see from the photograph there, although it's busy, it does not do it justice, because on a summer's day, our beach does get very busy, It's not quite to Sydney's Bondi, but it's our little Bondi, and we're very proud of it. Our lifeguards do an amazing job, especially on busy days. Their job is to patrol Brighton Beach, but also to provide a roving patrol along the creek, because we do have new families who are visiting the beach, but also with younger children use the creek regularly, and it does pose some risks. As I've said in my submissions, the creek generally runs through the south end of the beach, but again, that's impacted by the tides. It's not uncommon to see it changing to the middle of Brighton Beach, and I have on one occasion seen it running through the north end of the beach as well. So the whole beach is going to be impacted with any potential contamination here. Brighton Beach is dangerous. It does have a permanent rip, which the locals call Jimmy's Rip, but that runs along by Big Rock. But we have a regular rip that turns up by Barney's Rock, which is pretty much where the creek is currently entering the beach. So it's really important that our beach is monitored, but if there's a potential risk of contamination where people end up using other beaches such as Ocean View or Back Beach, which is further south, our club's not going to be able to monitor those as well. It's going to encourage people to stay away from Brighton, whereas we want to encourage people to come to a monitored and patrolled beach rather than encouraging them to go away from these beaches. So there's real risks to the community, and it's against what Surf New Zealand really wants to advocate for. So from the Surf Club point of view, we'd really be encouraging there be no landfill, and therefore there's going to be no risk to the creek and no risk to Brighton, as opposed to any potential risks. So I think that even just the potential of risk is actually going to have a bigger impact. We also have the beach education, which is run regularly at Brighton Club. And it's not just Brighton, our Big Rock School, that's a lot of Dunedin schools, but we do also have some out-of-town schools travel. Brighton's a great facility. It's got enough parking for the school buses. It's got the great facility if the weather's bad, but it's also got the fantastic beach for the children to do hands-on, and actually, rather than learning the risks on a PowerPoint, they can actually see it themselves from the beach. As a side issue, you could imagine school boards, if they know there's a potential risk of contamination on a beach, school boards themselves will prefer to not attend Brighton Beach and discourage any risk to their children by attending Brighton Beach for beach education. And finally, which I did not mention in my submissions, when it comes to the wildlife, I've added pictures of the penguins, and we obviously have quite a bit of a seal population often pops up at Brighton and can participate within our surf club training. But obviously also in an annual basis, the oyster catchers often nest right in the middle of the beach, and we have some locals put up some tape and waratahs trying to protect them. So the risk of contamination again to the wildlife at Brighton Beach is going to be an unacceptable risk, I would say. Other than that, I probably don't have anything to add. Really, the important points are in my submissions.
Thank you very much for that. Jane, any questions?
No, look, I don't have any questions. I'm an ex-lifesaver, so I completely understand all the points you're making. But I don't need to clarify anything with you. Thank you. But thank you for putting in the effort into preparing this. It was very helpful.
I have one question for you, Ms. Hannah.
Sorry.
That's okay, before you pack up. I just noted in paragraphs 13 to 14 of your written evidence, you're talking about perhaps the improvements in water quality over time, and that's obviously pleasing. And then you're talking about the fact that the ORC notify that the surf lifesaving when levels of bacteria are elevated, and that's a system that works quite well. So I was just wondering, in terms of the existing community perception about water quality. Does that come up often with the community? If there's a system, I guess, there to alert the community about the existing quality water issues, to what extent, I guess, is it already occurring with the water quality that's there now?
From a community point of view, it's there, it's always happening. We've got, again, that community perception that actually, and I think I've referred to it in my submissions, it's been known as Poo Creek for a reason. And I think the community, especially the older community, they know that, so they're still reluctant to use it. From a surf club point of view, we do get regular emails from ORC in relation to water testing and whether caution needs to be exercised. So it's our responsibility to at least put it out to the community and let them know. And through especially the summer months, depending on the heat and everything like that, the emails can be quite regular. And I think, if I recall, there was probably about 3 or 4 emails relating to water quality last summer. So again, we put that on our Facebook and just tell people to exercise caution. I'd say it's probably less now than it used to be. But as a local of 15, 16 years, I'm reluctant to still going there myself.
Yeah, sure. Yeah, I think that was the interested to hear from you. I guess just noting that you're seeing a bit of public confidence increasing perhaps over the most recent years, which is obviously positive.
Yes, I'd say probably the majority of people to use the creek are not locals.
Right. Okay.
It's the new people coming in who aren't aware of the previous issues around water quality.
Yeah. Okay. Oh, thank you.
Lovely. Thank you.
So just following up on that issue, so does the ORC issue a no swim notice? What is the nature of the emails you receive?
The emails, since I've been secretary, it's normally the levels are elevated, so it's advised caution. I think since I've, not as secretary, but while I've lived out of Brighton, I've seen that area there's been signs out to prohibit swimming in the water, and I've seen that, well, that I'm aware of a couple of times, but again, if you're not down at the beach, you often don't know if that's the case.
Okay, so you said 3 or 4 times over the summer that
was to advise, exercise caution due to the elevated numbers, but that wasn't saying the beach had to be closed or the creek was closed to swimmers. They just let us know that the numbers are going up. So if the beach is being patrolled, we just let people know, and there's a sign outside the surf club before they come down to the beach, just to let them know to avoid using the creek. But again, because of the rips on the beach, we have to then be more vigilant when people are going into the potential rip area.
Okay. To your knowledge, and you may simply not know, is there much of a history of illness from people swimming in that creek?
I'm not aware of that.
Yeah. I just noticed on a site visit it wasn't a water body I'd be jumping into in a hurry, or certainly not on Monday when we were
especially
there.
when you go over the bridge, it looks very murky and slimy.
Yeah.
And of course, well, and a lot of the exercises that the surf club children do, they tend to be above water, or you try to keep them above water. But children don't see those risks either.
Yeah. All right, no, thank you. That's very helpful.
Lovely, thank you.
Thanks, Karen. The next witness is David Grant.
Afternoon.
Kia ora koutou, good afternoon. I hope everybody enjoyed their lunch. As the principal of the school, the first question I was asked about coming along today was, will you be bringing children with you? And the answer to that was no. The sad reason is, in 2020, we took 4 children to speak to the council. Four children spoke on completely different issues, things that were important to them on Brighton Beach, the wider community. I'm not sure if it was arrogance or ignorance, but the children were treated, I thought, poorly. The questions they were asked after their genuine submissions were, do boys go to your school, and what's the name of the river? Which I found quite alarming. I would have thought due diligence, at least the council would know the name of the river. I don't think that's unreasonable. So that is why children aren't here today. That is no disrespect to you. Okay, but once bitten.
We do know the name of the creek.
Yes, I can see that completely. Like, there was no question about your due diligence at all. When I was growing up in Dunedin, I used to love going to Brighton Beach, as did thousands of other Dunedin families. The beach and the domain will be covered with people, cars, everything. That hasn't really changed, or maybe not as many cars on the domain as there once were, but the beach is still Dunedin's playground. Why is it Dunedin's playground? Because it is a great family beach. Safe for families, sheltered, clean, clear water, rock pools, Barney's Island. It's more than just a beach. Now that I've become the principal of this local school, I love it even more. Not just the beach, but also the Odour wetlands. I love it as a person, but also as a teacher. As a school, we use them both for two major parts of our curriculum. Firstly, aquatics. Our own program is called In, On and Under the Water. The children learn open water swimming, surfing, kayaking and scuba diving. New Zealand has an embarrassingly high rate of drowning. Our school is trying to do its bit to address this by utilising our local beach and giving our children real learning experiences. Not just swimming, but learning about the tides, rips and all of the other hazards that are presented with a beach, as well as different ways to enjoy it safely. The one thing we don't want to do is add another hazard. Our school also has a philosophy that we think is real, practical and meaningful. Our environmental philosophy is based on learning in, about and for the environment. You can probably see the obvious link to our aquatics program, but we know that if children experience and enjoy their local environment, they are far more likely to care for it and be genuine custodians and guardians. And our role as adults is to lead that responsibility and show them the right way. As such, apart from the aquatics program, the children are also actively involved in the Odour wetlands replanting, and they undertake science learning involving rock pools, sea, tides, erosion and pollution. In essence, Brighton Beach is a big part of our school curriculum, focusing on healthy, happy, active children who meaningfully engage in their curriculum and their community. It is worth noting here that not only is Brighton Beach Dunedin's playground, in many ways it is also Dunedin's classroom, with many local schools utilising all that is wonderful about Brighton Beach. The Smooth Hill landfill will put all of that at risk. And let's be really, really clear here. Anyone who thinks that it will be known as the Smooth Hill landfill is being very naive. It will very fast become known as the Brighton Tip or the Brighton Dump. Only in hearings do people refer to these places as landfills. I know that that will put an end to being Dunedin's playground, an end to the aquatics program, and an end to our environmental program as we know it. We know that COVID has created a lot of anxiety in children. Anxiety that they never had before about getting sick, being sick, and actually dying. We know that. The anxiety will be heightened if they even think for a moment that their local beach is being contaminated. If they just think that, they will feel that fear. They won't want to swim, they won't want to play in it, they won't want to surf or dive. That is a reality. And if they even think there is a chance of it being contaminated. I know this is true because they've told me, with phrases like, we won't be able to go swimming, we won't be able to go surfing when the water is poisoned by the dump. And if I can give I don't know if this is a good example or not, but when I was a kid, a long, long time ago, I was playing rugby when Sunnyvale first opened up. A lot of kids stopped playing sport because of fear when they were going to play Green Island teams. Not because of the quality of Green Island teams, but because there was rumours innuendo, what have you, that debris, waste, rubbish, as we would have called it, was coming back up through the surface. And that was a very, very real fear for kids. And as I recall, I was a kid at the time, so my facts might be a bit wonky, like an old baked bean can sort of thing came up through the surface and somebody was cut and a broken piece of glass came up through the surface. Because I think, and again I might not have this right, the use of Sunnyvale was sped up because of the Abbotsford slip and the Green Island Rugby Club was out of action. But there is that perception, and with children that's all it actually needs to be. The children today learn and know more about looking after the environment than any of us ever did when we were their age. They have the potential to lose enthusiasm for swimming, for surfing, for kayaking, for enjoying their beach, their wetlands. This is their local environment. And they will lose interest in learning and caring about their environment if they think their city council is poisoning it. They will lose the ability to care, and why should they, when the civic leaders, in their opinion, are showing them that they don't. It's not only the children of our school and Dunedin schools using the beach that will stop coming or caring. The families of Dunedin will lose a much-loved playground, Brighton Beach, especially in summer when it is packed with families from all over having fun. It is Dunedin's playground. People don't wake up in the morning on a Sunday or a Saturday and say, let's go to Mornington for a picnic. They don't wake up and say, we're going to go to Corstorphine for a picnic. They go to Brighton. So ask yourself this. Would you bring your family to a beach that is potentially contaminated? Even the perception of it. Would you? I wouldn't. It will be a beautiful beach that shares its name and rough location with a tip. It doesn't take a genius to work it out. So Big Rock Primary is absolutely opposed to Smooth Hill Brighton tip.
Thank you. Let's see if we have questions. Rob, any questions?
Thank you. As a Dunedin resident, I've spent many times at Brighton Beach with my family, so I can appreciate the importance of the beach and the surrounds to the community. I guess following on from my question to the last witness around the public perception, so there's been an historic perception that the creek perhaps is contaminated.
Only locals dive off the bridge into it, in my experience, as a kid and as an adult.
Yep. And so I guess my observation is that even with the existing public perceptions on the existing water quality, people still flock to Brighton.
Yep.
And so I guess just interested in how you think that, I guess, reconciles with your thinking that people may no longer visit Brighton or enjoy Brighton if consent were to be granted and the consent conditions were robust, comprehensive, and there were similar monitoring programs going on by the ORC as there currently is, with the alert system to the Surf Lifesaving Club. Yeah.
Well, I think on two things. Firstly, I'm seeing already from children that they're really scared of it now.
Yeah.
Even just the concept. And the second thing, my mind's just gone blank. It would only have to happen once. If there was a water warning, like we've had under current circumstances, even if it happened, if we had another one and there was the landfill, people would put 2 and 2 together and come up with 5. I think that's very, very real. I just think people will make their own assumptions. People aren't going to analyse the science. People are going to go, that's there, the water's there, that water's poisoned. They are going to do that. And there's Blair said before, if there's a fire, that's going to heighten it. So I just think I think the concept of that people will just fully understand the science. I don't think it's going to happen.
Okay, thank you.
Jan?
I was just interested in you mentioning the children getting involved in the planting that
Yep.
the Trust is doing. Can you just explain a little bit, how does that work with your curriculum and so on?
Right, well, we've got this concept. I spent early days of my principalship out at Waitati, a very environmental school. I went there not as an environmentalist, I'll be very honest, but I learnt a lot from the community. And that's where we came up with the concept of learning in, about and for. Not just teaching kids recycling, but learning in their environment, doing the stuff like you see behind you, or it might be on the screen in front of you, sorry. So they're doing the planting, looking after their environment, using the beach for active things like swimming, surfing, etc. And then classroom stuff, the deeper book science, if you like. So that links it all together, ties it all up, and when the society, the community trust group that came to us, we were more than happy to get on board because it is the start of something we think really special.
Right.
And it would be really ignorant of the school and probably negligent if we weren't involved. And if anything, we probably want to get more involved because it ties everything together. And in current curriculum design, schools are beginning to put together what's called local curriculum. We've been doing it for about 4 years. We're quite ahead of the game. So that is a really good example of what other schools should be doing and could be doing, and probably are doing. I don't want to disparage other schools because that's certainly not what I mean. But it links to what our school's philosophy is about caring about where they live. Because schools get caught up in worrying about polar bears. Kids at Brighton School, Big Rock School, can't worry about polar bears. Look on your own doorstep first and then broaden it. Because they have to be the local guardians and custodians. We're not going to be there forever.
Do you have any school programs that go up into the forest and that sort of thing?
Not the forest as such. We do based on school camps, but that's more activity based. And we do the native bush stuff in places like out at Wailora, Fraser's Gully, which separates sort of Brockville and Halfway Bush.
Okay. Otherwise, I understand everything in your evidence. I don't need to ask you any more points of clarification. Thank you very much.
Just 2 questions for you. The first one, because you're a school teacher. How do you pronounce the name of the creek? Otokia, Otokaya, Otokia? I've heard quite a few different ways of saying it.
Otokia. Otokia.
Otokia. So is that generally what
But I generally, and I'll be very honest, I have to concentrate to do it. It doesn't just flow out of me just yet. Because I was initially saying it incorrectly.
Yeah.
There's a hyphen on the O, so you accentuate it all.
Otoki.
Thank you. So when you say Brighton Beach, in your mind, is that the beach and the ocean, or is it the beach, the ocean and the creek?
It's the beach proper, Brighton Beach, the bay, if you like. It's the creek, but it's also the beach on the other side. Some people call it Back Beach. It has different names because that's where the rock pools are more accessible for children. So it's the whole area there. I would, I don't think I'm brave enough to call myself a local, but I would say that I would refer to it all as Brighton Beach, but that would be incorrect. But the other side of the bay, sort of at the back of the school, if you like, I would consider that, but it has, I think there's about 100 back beaches and middle beaches in Dunedin alone.
All right, thanks very much for that. No further questions, but thank you for your evidence.
Thank you.
Thank you. The next witnesses I'd like to call is Victoria Kahui and Simon Lang on behalf of the Otokia Trust.
Tēnā koutou commissioners and tēnā koutou katoa to my fellow submitters, the applicant and the Regional Council. Ko Simon Lang Odour, I'm the chairperson of the Otokia Creek and Marsh Habitat Trust. If I may just take a moment to thank, in the shadows down the back, Karen Bagnall and the rest of the ORC team. They've done a great job putting these hearings together and keeping us informed along the way. Sorry, I understand I answer to you here, Mr. Chair, but my mum's watching this, and if I don't thank my host for having me, I'll answer to her later. I do wish to address previous submitters' observations. Before I do, I may have just a little bit of input, and I wasn't planning to, but in regards to recent fires in the region of the landfill. I am an operational firefighter with Fire and Emergency New Zealand in a volunteer capacity, and I report to Brighton Volunteer Fire Brigade. I think Blair may have mentioned a recent structural fire, which was early in 2020 during the first COVID-19 level 4 lockdown. It was a structural fire with no persons reported, and I was first on the scene with 3 others in the first responding appliance. We got there rather quickly. We are the closest brigade or station to the landfill site, and we hit it with water very quickly. It was a large 2-storied structure positioned closely to a nearby residence, and we were able to save the residence as it was beginning to ignite. And we could have saved the structure that was alight. The reason we couldn't save it is because we regularly and consistently throughout the event ran out of water. When we're fighting fires in that area, we are reliant on trucked water rolling in tankers. Foreign emergency uses local civil engineering contractors like Fulton Hogan and the like to supply tankers, and they just can't keep up. I couldn't tell you how many tankers we used, but they were intermittent because they had to go back to Brighton to fill up at our fire station at the hydrant. As a result, that property burned to the ground. We couldn't save it. So that's all I have to say on that. I would like to comment on Sandy Graham's evidence. She indicated that Dunedin City Council didn't wish to assume that a community consultation process would be in the best interests of the community. We are community members, and we wish we had been provided with meaningful consultation. It is clear that the DCC actively avoided community consultation throughout, and this is evidenced by the fact that they requested this application be limited in limited notification. One thing I failed to mention, I'd just like to take a brief moment now to acknowledge the passing of Otokia whānau Kaumatua Pōropata, who passed away just earlier this year. Paul was widely considered the kaitiaki of the Otokia, and we had expected him to be here with us today. He would have liked to be here because it was his assertion that while mana whenua has been consulted as promised, tangata whenua has not been. The people that live in Brighton. I have a comment also on a previous submitter's evidence. Jazz Morris, is it Dr. Jazz? Dr. Morris has come to the conclusion, which I believe to be flawed, that the biodiversity restoration plan commissioned by Otokia Creek and Marsh Habitat Trust and developed by Wildlands Consultants will offset somehow a loss of habitat or biodiversity from the proposed landfill. We are not undertaking to restore our whenua, our wai, for the benefit of the City Council's infrastructure aspirations. This work the Trust is undertaking is not in any way intended to mitigate the effects of the proposed landfill. So given this riparian fencing and planting Dr. Jazz spoke of will happen regardless, the landfill proposal may not include this plan in any goal to achieve any net positive habitat development. Dr. Jazz also discusses the need to manage pest plant invasion to the wetland on the, I believe it was the upstream side of McLaren Gully Road, which you were speaking to Dr. Lloyd about earlier. Mm-hmm. This will also be an issue which may not have been evident in Calvin's evidence on the downstream side of McLaren Gully Road, and the panel may have noticed this when they were at that point near the V-notch weir. If you look downstream, you'll see a grassy swamp. Yeah. This site will also suffer from a drying effect from stormwater retention on the landfill site. This area is part of a privately owned freehold rural property, and so how does the council has proposed to conduct vegetation management on private property that they have no access to? I have a comment on Alan Engel's evidence, where he seems to have made his assessment on the flow of the creek at McLaren Gully Road based on a site visit in October 2018. Matthew York, a trustee on our board, has made site visits to this area every Sunday morning for many years, and his anecdotal evidence of flow rates should not be so easily discounted. But I imagine Mr. York will speak to that himself. I also note that Mr. Ingalls claims a more accurate transit time through the creek from McLaren Gully Road to Brighton Beach would be in the order of 4 hours. We also consider that 44 hours or 45 minutes is either or. It's a very short transit time in the event of any contamination event. And there may be a consequence to water monitoring requirements as a result, perhaps the intervals between monitoring events. Tanya Blakely, I think she did an ecological assessment, has made the point, which we happen to think is an excellent one, that an environmental DNA sample that was taken by our trust was further down the catchment from her own survey. It is our view that the fish survey commissioned by the applicant is of a poor quality and was undertaken at the consultant's own admission at the wrong time of year. Environmental DNA samples could easily have been taken at multiple sites in the area at different times of the year to establish a better picture of the existing ecology. However, low quality assessments seem to be a theme of this application and are indicative of the rush nature of it. Rushing may result from a lack of forward planning. The requirement to eke out another approximately 6 years from Green Island is an example of this lack of forward planning. I'm nearly done. Just to wrap up, Otokia's forests, swamps and marshes are a valuable carbon storage asset. A landfill to replace a forested block of land within a network of interconnected wetlands will certainly diminish this natural asset. What seems to be less prominent in mainstream discourse is the question of what legacy of biodiversity, or lack thereof, will leave our tūhanga. Biodiversity loss and climate change are driven by human factors and mutually reinforce each other. The 5 main drivers of the biodiversity crisis are habitat loss, direct exploitation of species, climate change, pollution, and invasive species. This application, if approved, will incur a loss of habitat. It will cause pollution. It will certainly attract invasive pest species to the area. Nobody here today, or that have submitted to this commission so far, belong to the generation that will receive the legacy of reduced biodiversity. This proposed landfill would bring 3 of the 5 drivers of biodiversity loss to the Otokia Creek catchment and surrounds, and leave a less fortunate future to our descendants. Would you like, if you have any questions, would you like to go now, or would you like to hear from my colleague, Dr. Kahui?
Whatever is best for you as a team, whatever you think would be most helpful.
Perhaps deal with me first, because Vic is a more formidable foe.
Okay. Ros, any questions? And Jan, any questions?
I just had a couple of questions, but actually they might go to either of you, so let me just about the trust really. One of them was in your evidence, your joint evidence. You referred at paragraph 3 to this trust being formed in September 2020, which seemed to have some sort of coincidental date with the landfill being more widely known. Is that right?
I'm not a conspiracy theorist, and I do believe in coincidences, but this is not a coincidence. So the trust consists, while there are 5 trustees on the board, we have a wider membership of dozens of people, many of which are creek adjacent landowners up the catchment, and many other interested people in the community. A lot of the work the Trust has been doing we were doing together long before we formed the Trust, and this application, if anything, has been a catalyst to us formalising our structure. I hope that makes sense.
No, absolutely. I sort of thought there would be some relationship between the two. Then, at your evidence at page 45, you talk about being concerned about litter from the trucks. I'll just find it myself. The landfill at Smooth Hill will increase the volume of litter from trucks carting wastes into the creek and marsh. Now, do you understand, both of you, that the trucks are to be covered? Which tends to mean they have a rather large sort of tarpaulin-y whatever going over the back that's sort of pinned down.
Yeah, I agree, and I also have personal experience in waste collection. Best job I ever had was chasing a garbage truck down the street like an Alsatian. Rubbish trucks, by their nature, as you deposit into them, collect litter under the guards. Usually transfer stations have litter on the ground, which collects in the mud guards around the wheels and between the wheels on dual wheel axles and things like that. You show me a clean rubbish truck and I'll delete that from our submission.
Okay. Have you been tuning in and out during the week on the live stream? Okay. Did you hear me ask a question of the applicant a couple of days ago now about picking up waste, if this was granted, to whether they would agree to pick up litter from properties and so on, public roads? Is there anything you wanted to say about that kind of matter? I'll put it that way.
No, but given the location of the site is on top of a hill, it's a very windy location, so I think that is certainly a requirement that would need to take place, yeah. They need to have quite a vigilant crew monitoring the roadsides and all around the area, not just on the landfill site, I imagine.
Okay. That's all I had, because I understand all the other parts of your evidence so far, anyway.
And no further questions from me, thank you.
Kia ora. My name is Victoria Kahui. So I won't be long. I think Simon has mentioned some of the important points to us. I'm in the fortunate situation that I do wear two hats. So I have got a PhD in economics and I teach at the University of Otago. I teach environmental economics and I've been doing so for 15 years, two large undergraduate classes. I'm also a trustee, so I haven't appeared as an expert because I am personally involved. However, I just want to comment on a couple of things. I did make a submission personally, and the commissioners picked up on one of the submissions by myself and others, asking Greg Akers, who prepared the economic assessment report, why he did not follow the Treasury's living standard framework. And Greg responded that this is usually, the living standard framework is usually applied on the national level in order to, for budget bids, and that councils typically follow the Resource Management Act and having to satisfy environmental, economic, social, and cultural effects. So he basically suggested that the evaluation of these effects falls to the DCC and their hired experts. So I agree with that. He nicely clarified that. In his report, he measured the economic impacts by employment, gross output, and value added. And he does state on page 21 of his report that value added is an indicator or measures well-being. Now, the reason why I brought up in my submission the living standard framework is that this is exactly the thing the living standard framework addresses. It is a measure, but certainly not the only measure. There is a number of domains the living standard framework addresses, and I take it that typically what you see in local councils is the application of the RMA as opposed to a social cost benefit analysis. So my question then is, given that is the case, why is there no social impact study? So because one of the requirements of the RMA is to consider social effects. So one should not compare the effects, the economic effects, as being a social effect. I mean, it's part of it. It clearly contributes to the wider societal impact in terms of infrastructure, employment, and so on, but it clearly isn't the only one. So typically what you see in a living standard framework or any sort of framework applied to this is some sort of application of, let's say, total economic value. You would see something use values, non-use values. And if that was actually done by the council, they would have picked up on all these things that we are here representing: kayaking, fishing, using the river for swimming, but also the ecosystem services which Simon alluded to. I mean, we are actually acting really according to the intent of the freshwater policy and the ORC's biodiversity plan, of really trying to store carbon, build native plants, water purification, and so on. So I think this is completely missing from the DCC's application. There's no dedicated report, there's no single mention of any of these values. So, and I think that reflects back to the complete lack of consultation. So the commissioners did raise the idea of a community liaison committee, and I think that's an excellent idea, and that has been completely missing, because this is something that would have been discussed or at least identified in that process. And this would have also picked up on the perceived risk of leachate from the landfill, which is something that you would have heard from several members of the community here. And I think especially as a trust, these numbers in these tables that we provided are not made up. You know, we keep meticulous records. We're spending a lot of time on engaging with the public. So I was just telling Calvin, half of our time spent on planting and the nursery and other things, but the other half is actually relationship building. It is actually administration, relationship building, communicating with the public. And for us, we all do this voluntarily. We have big jobs, we have families, and we do this on top because we believe in it, we enjoy the beauty, and putting a rubbish tip at the end of the headwaters of a creek would have a real demoralizing effect on our intentions, which are really in line with what the government is wanting us to do, and the regional government. And my last comment, and I'll be brief, is just regarding to the so Christopher Henderson supplied an extra additional evidence or information stating that the DCC has explored multiple options for waste disposal during feasibility studies conducted as part of the business case process for Smooth Hill. Now, this business case program, I've had a look at this last year, and I looked at it again. It's actually recorded, some of the details around that are recorded in the DCC meeting notes from Monday, 11th February 2019. And they discuss this, and they have an attachment to it. So when you peruse and read through it, it's very scant. It's a couple of pages explaining it. And what they're doing is they're basically stating things like there has been no change in relevant criteria upon which the council has made its decision to select the Smooth Hill site since in 1992. And they're identifying different types of programs, potential programs, amongst which they chose according to some multi-criteria analysis. Now, that's all it says. There's no sensitivity analysis. We don't know what the criteria exactly are. They list a couple of them, but they don't actually specify them. They don't provide any sort of discussion around, they talk about workshops and discussion with stakeholders. Who are these stakeholders? Where were these workshops? So this is also something interesting, because in the economic assessment report, Greg Eckhurst also refers to that. He actually says that there's no sensitivity analysis or has not been applied, as it forms a key component of distilling the options originally. So as an economist, when we get any sort of data analysis, any sort of econometric analysis, at the bare minimum, we provide some sort of sensitivity analysis. What happens to our results when we change one parameter by 1%? How does that affect the effect? It may not affect them at all, but we're able to at least confidently state that these are the variables, these are the levels, this is what happens when we change one or two variables by some margin. None of that information is provided, and it it is very difficult to assess as someone outside this process how robust it has been. And given that it is absolutely instrumental in deciding the location of the landfill, I think this is really important. And I would like to I personally would like to have a look at some of the analysis around that multi-criteria decision. I did put an OIA in, I never heard back. I didn't follow it up, I should have, but it just got swamped out. But I would love to see some more information on that. Thank you.
Thank you.
Thank you.
Jan, questions?
I haven't got any questions on that because I understand what you've been saying, so no problem.
Excellent.
Thank you.
Any questions? And no questions from me either. Thank you very much.
Thank you.
Thank you. Next witness is Andy Hutchin, who will be joining us online.
Hopefully I'm coming through.
Hello, Andy.
Hello.
I'm on, but I'm not on with them yet.
So we've got.
I'm on with you,
sorry.
I'm not on with them.
We've got one chap with headphones on and one chap without,
Yeah.
and I'm not sure.
So the one we want to talk is the one without the headphones.
Yeah. I'm Andy in the blue shirt.
Thanks, Andy.
So do I just talk, or?
Well, do you have anything you'd like to add to your evidence, or would you just like to take questions?
I would like to briefly respond to a couple of the expert witnesses who've spoken in the last few days. And I suppose I should stay up front as one of the Creek Trust trustees and things. I share many, if not all, of the concerns that we've been hearing today, but I don't want to take up a lot of time reiterating those. As part of my background, I guess I was a herpetologist. I ran a Grant and Otago skink recovery program for the Department of Conservation. So I want to lean a little on what I learned doing that and hopefully a little expertise that I have from that. So when Ms. King gave her evidence, I noticed she made the comment that the skinks that I used to manage were larger bodied skinks that have a different predator response to the smaller southern grass skinks that we believe are probably at the site. That's true, but really my concern is around the effect of predator control. You know, she mentions that some predator control would be done to support translocation and things. Now, I ran a big trapping operation, and I would say that a key thing is the size of trapping operation you need to have any effect at all on predators, because we're talking predators that move a long distance across a landscape. I mean, I won't try and dig out the old statistics I had. There were a lot of logistic regression things that showed that you needed many hundreds, if not a kilometre or two of predator control to effectively reduce predator levels. So the individual effect of predators on different species is kind of irrelevant to me in this, because the presence of predators isn't going to be affected very much by small-scale local predator control. And I think that, that may have been a misunderstanding between Ms. King's response to my submission there, that the issue is if predator control is going to be worth anything, it has to be large enough scale to be effective. I was also a little concerned that she was saying if there were only small numbers of animals detected, then it would not be cost effective to try and trap them, live trap them for the purposes of translocation. And I guess this says two things to me. One is that if it's not cost effective, then somebody's not putting a very high value on the lizards, are they? Because cost reflects value. And the other thing is, yeah, this is true. It's difficult to catch these animals. I know I used to go out into the field and do that with several species. if you don't think you can catch a small number when there are a small number present, then if you go out to do a translocation when there are a large number present, you're only harvesting some slice off the top of the population. You're not catching all of them, because you've already admitted that if there were only a few of them, you couldn't catch them. So if there are a lot of them, you can't catch all of them. So it casts a bit of a doubt to me on, I guess, what the purpose is, where you're just taking a few animals and moving them to rescue the lucky ones, perhaps. And I also have a belief that species go from being common species to critically endangered by losing their habitat kind of a square metre at a time. And any habitat that's lost has, is part of that impact. And that goes equally well for losing the grassland habitat along the roads when roads are widened, and indeed for losing falcon habitat, because you have a plan that says if falcons are nesting, we'll let them finish nesting this year, then we'll destroy the habitat that we're using and make it unavailable for next year. So where are they supposed to go next year? That's about it on the lizard and other wildlife side. I had another passing note that Mr. Engels was casting some doubt on the transit time for water down the creek. Now, I'm not an expert in this area, but I spent a decade and a half living next to that creek, crossing it almost every day to feed livestock and things like that. And I can certainly say that when in flood, that's a creek that would rise 2 or 3 meters above its normal level across my property. And while I never measured the flow rate, it was moving what I would call extremely quickly. And a 40-minute transit time from the head of the creek to the sea, he quoted, I think, 5 meters a second, which is 18 kilometers an hour, as the necessary flow rate. And I'm pretty sure I was seeing flow rates that would have been at least that fast. So, I guess I am unsure of him claiming that it must be a 4-hour transit even when the creek's in flood. And I'll leave it there in recognition of the fact that we're probably quite tight on time, thanks.
Thank you. I'll see if we have questions for Mr. York. Any questions?
Thank you. You've actually answered a lot of the questions that I had written down for you, but I do have one remaining one regarding your concerns around the salvage approach, the salvaging method. So I had understood Ms. King's concern was that it's not cost effective when compared to the gains that you could achieve through the translocation and the effort put in somewhere else. Am I understanding that correctly from where you're sitting?
Are we probably all agreeing that there comes a cost at which actually spending that money on some other form of conservation would be more worthwhile?
Right, so you were concerned with the specifically around not capturing 1 or 2 individuals.
Yeah, I guess I'm observing that she says, it's just not cost effective to capture a few individuals because they're hard to catch.
I see.
It also means that if there are a large number of individuals, if you try to catch them, you're going to miss a substantial proportion of them.
I see, I understand. Thank you.
Thank you.
I haven't got any questions for you. Thank you.
Mr. Your eDNA sample, just remind me exactly where did you take that sample?
It was Matthew who did the DNA sampling, so I will defer to him on that one.
Okay, sorry. All right, I'll ask that question again then. Thank you. No further questions for you then.
Thank you very much.
Thank you.
So the next witness I was planning to call was Matthew York. I just wanted to, because I know you indicated you wanted to adjourn at 3. Is it bang on 3? Or have we got a little flex in that?
No, we need to be packing up and leaving about 1 minute after 3.
Okay. All right.
But we do have Tuesday.
Yes.
Can you spare time on Tuesday? I'm more than happy, if that's inconvenient for your witnesses, for them to either Zoom in on Tuesday, or we can sit late on Mondays. If they're working during the day, we can hear them after working hours. We're totally flexible. We don't want to disallow anyone speaking to us.
Yes, I understand that. I'm just trying to jig the witnesses
Yeah.
to work around that availability. So what I propose to do is to call Matthew next, and then Mr. Kahui to close today's proceedings. And then we would hold over and Claire and Loveday to Tuesday.
Right. Okay, thank you.
So if we could have Matthew, please.
Yeah, I'm here. Can you hear me?
Yes, we can. Thank you, Matthew. Do you have any further comments you want to make?
Yeah, I've got a few points here. First of all, I'd like to say that I am a local. I have lived in the area for 45 years. And as a kid, yes, I used to be one of the ones that jumped off the bridge, swam in the river, probably swallowed vast quantities at that stage. And it never really seemed to have too many effects on me that I know of. Certainly no long-lasting effects anyway. On some other matters, I've got some replies to points that Mr. Ingles brought up in regards to my evidence. I never actually mentioned a cubic metre per flow rate, cubic metre per second flow rate, because as he noted as well, a flow rating chart for the weir, that's the little V-notch weir at the top, it would be pretty much impossible to calculate that, certainly well above my level of capabilities, just due to its location and the shape of the riverbed up there. So the flood levels shown, or the flow levels shown in the chart, they're just a direct measurement in millimetres over that weir, read off the level staff. They're not a flow measurement in cubic metres per second or anything like that. That data is available when the creek is actually flowing over the weir within the confines of the V itself. Once it gets above that V, anything above that is an estimate, and I don't really like providing estimates to do places such as this. So the flow across the road, it's spread over a very wide, long area. The flow measurement was taken with a handheld flow meter, and at that stage of the game, it's getting a bit old now. It does need calibration at the moment, but it was only 2 weeks old straight out of the box. So I class that as still being factory calibrated, and I'll be quite happy to go with that. These readings that were taken as far as I could reach at several different locations across the flooded section of the road. They averaged out to be 32 kilometres per hour. So the way the road is shaped, it basically builds up gently like a dam and then flows over the far side of that road. 32 k's now, of course, works out to 8 metres per second, give or take a couple of zeros. And I can say there was definitely visible damage to the road. So the road was affected. It was still drivable on, but it was definitely affected. There was a lot of the gravel surface was washed away back down to the harder material underneath that road, and a lot of that gravel was spread quite a distance out into the paddock, in some cases 30 to 40 metres out into the paddock. And they did actually have trouble with the creek further downstream being partially blocked up by the gravel off that road, so there was damage to the road. And forestry roads further down the catchment, we had 6 metre long pipes, 1,200 mils in diameter. I had one of those made out of steel. It lifted it right out of the road and floated it through the middle of my V-notch weir further down without actually touching it. So that's the power of the water. I put it a good 4 metres up the bank. So the creek down there came up a good 3 to 4 metres. The transit time that I had, it was worked out using a model that was free to the internet model at that point from the US Army Corps of Engineers. I no longer have this program. The free version of it doesn't work on Windows 10, and I can't afford the rental cost of the actual program itself, and I have trouble recalling what that program was called. But transit time was worked out based on bed slope and stream side conditions, as well as flow recordings. And this can vary greatly between different modelling programs. It can also vary greatly between the accuracy of the data that's input into these modelling programs. And I have tried to put the most accurate data I can put in, but being in a limited capacity for equipment, that's the best I can do, basically. It's the best I can say. So the other point is that it's not 13 kilometres from McLaren Gully Road to Brighton Beach. It's actually only 7.2 kilometres. And I have walked all 7.2 kilometres, so I do know what's in there. A point I feel worth noting is whether it's 40 minutes flow transit time as I stated, or 4 hours as Mr. Engel stated, it is still a very short time, allowing very little response time for leachate release were to occur during a flood event. And as you've got in my written evidence, there are a number of recorded flood events in that catchment, and that is the second or possibly even the third one of that size in the time that I've been recording since 2013. And that's recording on a close basis. That's not, oh, it's raining, I'll go for a drive. That's going every single Sunday, or any time I feel there's going to be a flood event across that road or across that area, I go out and have a look. I tend to get very wet, and my vehicle tends to end up quite water-sodden at times, but it's very interesting. The main reason I study this creek is because my hobby is hydrology. It's the closest creek to me, so it's the one that I'm playing with, basically. Now, in response to Tanya Blakely, and it was a question you asked a few minutes ago, Mr. Chairman, the eDNA sample, it was taken at the last point of visible flow before the water entered the estuary. We have a fair idea what's in the estuary from observation, net trapping, nighttime fish surveys with torches, etc. But some of the smaller stuff, and in the pool and riffle sections above the head of that estuary, we had an idea what was there, but to get a better idea, that's where we took the eDNA. So it was actually taken in the bottom of Andy Hutchins' gully, a little spot where the water runs out of a pool, trickles down over a bank under a fence, and into where the head of the estuary starts. And it was selected there to allow a snapshot of life present in the creek from that point up, and it actually had nothing to do in any way with the Smoothville Landfill proposal. It was basically an awesome opportunity from the Environmental Protection Agency through a company in Wellington that allowed us to get hold of that test for nothing and do that test at a point that we deemed fit in the catchment. And my understanding after talking to EPA is that you can pretty much take an environmental eDNA test, you can get it out of a puddle of water. You can get it out of anywhere where you can get enough water to strain through a microfilter. And certainly there are methods to get samples out of things like ponds and that if you can't get safely to them. There are things like sterile scoops on long poles and stuff. I have used this to take water samples of stuff before. So in my mind, there's no reason why they couldn't have got eDNA samples virtually anywhere there was water standing in the catchment. And that's pretty much all I've got to say. I'm willing to answer any questions you may have.
Thank you very much for that. Ros, any questions?
I have no questions, thanks.
Just one other question. Thanks for describing where you took your eDNA sample from. In terms of the flooding matters, what's the relevance of flooding matters in the creek to this landfill application?
I feel that the creek up there remains dry. I've put that in my other evidence as well. The creek up there remains dry or a very, very low level for a long period of time, therefore allowing any long-lasting or any leachate type material to perhaps get into that pond, potentially contaminate that pond. We are talking about landfill here. I do look at the Kaikoura estuary, and I know it's an older style landfill, but there is signs of leachate in that estuary. And I do a lot of reading and research, and there are other areas around the countryside where they have landfills with liners that do leak. So, and even the amount of leachate that they're stating will get through their liner. So what I'm suggesting basically is that what will happen, the water that leachate will sit in that creek bed, perhaps dry out, leave settled deposits behind in the creek bed. Then a flood's going to come along, pick all that lot up, and take it right down to the beach. And it's going to take a very short time to get there, and there's going to be absolutely no response time to do anything about it when it does get there. And as has already been pointed out, solution by dilution is not an issue. It's not a problem solver, sorry.
Okay, no, thanks very much for clarifying that. No further questions.
Thank you very much.
Thank you. So with the time we have, I'm actually going to be ambitious and call Anne Claire to present her evidence next.
Tēnā koutou katoa. Thank you for letting me speak today. I didn't sleep last night, so it's a relief I can talk today. I was also hoping to speak before Komatua Edison speaks on Monday and can hear what I have to say today. So thank you for letting me speak. So I would just like to respond to Mrs. Megan Lawrence's report, which is a thorough report of historical features within the Smooth Hill area. My evidence addresses the archaeology and history of a wider window than the Smooth Hill parcels. It addresses the archaeological features in relation to the Otokia River that emanates from the Smooth Hill and the associated landscapes, Hills, Marsh, and Brighton Township. So firstly, about the archaeological features that were recorded. So if you have in my brief of evidence the map that I provided. So those archaeological features were reported along the river by notorious archaeologists in the 70s and 90s, such as Jill Hamill and Brian Hallingham. And during the investigations, areas of previously destroyed features, such as Umu, were also pointed out to them by forestry workers and farmers. At the time, a paper record of these features were provided to Heritage New Zealand. Some records were deleted following the destruction of those archaeological features, subsequent to forestry work. Some others were downgraded from Umuti to Midden in the last 20 years by surveying archaeologists. This is malpractice, and this is a nationwide problem that is currently being addressed by Heritage New Zealand. So artifacts are also found in isolation on the riverbanks, including several Ponamutanga, which is highly significant in Māori culture. And other artifacts such as adze and grading slabs attest of human activities. So all these features mentioned above do not appear in the ArcSide online database, only in the literature in the museum records. So it means that the map that was provided by Mrs. Megan Lawrence doesn't provide that information. The other thing about cultural landscapes, I just wanted to bring a clarification. And first, as it is defined by the UNESCO, cultural landscapes are combined works of nature and humankind. They express a long and intimate relationship between peoples and their natural environment. The recording of cultural landscape is a work in progress in New Zealand. Projects are driven by iwi and archaeologists, mostly in the North Island. In Te Waiponamu, the Naitahu Atlas was initiated years ago and is now being updated, as lots of information is missing, as it is the case for Otokia and Papakayo Brighton. So the recording of cultural landscape relies on physical evidence provided by archaeology, coupled with ethnographic evidence, or oral history. To illustrate that perspective, I just would like to imagine archaeologists from the future visiting Brighton Township, investigating it. So their recording will address buildings, the school, the houses, the dairy, but probably not the beach, as no feature is visible. But this recording will not reflect daily human activities on the beach. Swimmers, the walkers, surfers, beach volleyers, fishermen, divers. So the Otokia landscape is not an empty archaeological landscape. It was the place of Mahingakai, of Wahitupuna, and seasonal occupation for Tangata Whenua established in the Taieri Mouth Kenga, Maitapapa. Unfortunately, by 1930, a high number of Maori families had to leave the Kenga. The Malay and the Mana over the land subsequently disappeared. And not all the stories. The Otokia is a landscape of cultural significance from a Tangata Whenua perspective, but also from a historical perspective, just to answer the question you addressed to Megan Lawrence, as supported by the evidence I provided. I am concerned that the perception of Tangata Whenua relating to the cultural landscape was not heard. I am concerned that residents with historical ancestry attached to the Otokia were not heard. I am concerned that mana whenua from Te Runaka Otako was provided with incomplete information relating to the archaeological significance of the Otokia landscape. Thank you.
Thank you. I'll see if we have questions. Ros, any questions?
Thank you. We spoke with Megan Lawrence earlier in the week and asked her some questions because we noted your concerns in the submission, in your written submission. She explained that it's not her kind of role in the process to put forward her views on non-physical indications of cultural associations. However, that acknowledges the potential that there would be many unrecorded physical examples, potentially, and if they were uncovered through any works, there would be the standard conditions of consent, which would require the appropriate response. Have you had a chance to consider that response from Ms. Lawrence?
Yes. So, yeah, the first aspect is I think she could have considered the historical significance to people. This is what I do. I work closely with iwi, with tangata whenua. So first with mana whenua and then with tangata whenua to provide them with archaeological evidence to help them with the revitalization of the Mataranga. This is what I do. So I'm not taking the place of mana whenua here. I'm just providing evidence that is not in the historical report of Megan Lawrence.
Okay, thank you. We'll be hearing from Mr. Ellison next week, as you noted, and the submission from Mr. Ellison and also Okahara, I think, is informed by quite an extensive the Ngaitahu cultural mapping digital resource as well. So it'll be interesting.
Which is a work in progress. As we talk, there are people working on extending that database that covers a big area of the South Island. So there was, big project. But as I said, that's a work in progress. Yeah.
Sure. Yeah. Oh, thank you.
Jan, any questions?
I have no questions for you. Thank you.
Thank you.
No questions from me either. Thank you very much.
Okay, thank you.
So we have 14 minutes. We've got Love Day and Dennis's closing to go. So do you think you'll have many questions for Love Day? Do you think you might fit him? Dennis thinks he'll be about 5 minutes. So that leaves us with 9.
Be precise.
I'm great at maths, below 20.
Just find the evidence.
You're using their first names, which is confusing me.
Sorry,
so I've got them
Love Day
listed by
Y.
surnames.
And Mr. Kahu to come.
To assist with that calculation at our end, how long does Ms. Y think she might be?
3-4 minutes.
Oh, okay.
Very brief.
Yep, that's fine.
Right, let's do it.
Okay, thank you so much for giving me this final little piece of time, and thank you for reading my submission as well. So I hope in the submission I was able to convey the vital importance of Otokia Creek and the surrounds to the families in Brighton and then those who come to Brighton from the wider Dunedin area. So my submission was mainly about the unquantifiable benefits of having that free access to that safe, beautiful waterway that we are replenishing with the Trust. I did want to just respond to one question that you've already asked, and that's about the bacterial blooms that can come through the creek occasionally on those hot summer days, and the idea that, well, if the locals can kind of accept that, then what's the problem with further contaminants? And really, we're concerned about the build-up of those POPs, those long-term leachates, and the effects that will have on the waterway longer term, on the families who are immersing in the water, and then also on the wildlife around the creek and on the trees that and the bush that is being planted by the Odour Trust. So I hope that might help to clarify that there is that, quite significant difference between the two types of contaminants and how they impact our enjoyment of the environment. So I just wanted to say as well that it was a very, you can probably tell I'm quite nervous, but there's also a lot of emotion involved in the putting together of these submissions from all of us, even from the experts. But perhaps my experience was that was a little bit more kind of clear, particularly in gathering those words from the children, from the preschool and the community. And this is why I said it's the unquantifiable that my submission deals with, which makes it a little bit tricky because we don't have statistics for them. We can't kind of come to an objective agreement about them. But I believe that what matters is what we're going to be leaving our children and our grandchildren. And that's why we're so concerned about the leachates and the POPs, because of their long half-life. It might not be us who receive the impacts of those. It is, unless there is some horrible catastrophe in our lifetimes and things split or break apart or liners fail, it's much more likely to be our grandchildren and those who we are trying to raise to be kaitiaki and onward stewards of our home. So thank you, and I'll take any questions.
Yeah, thank you. And just in terms of that issue you raised right at the start, we do understand that I'm prefacing this on the assumption that the historical septic tank problem has been resolved, but bacterial contamination and result to agricultural runoff is episodic. It comes and goes, and we do understand the difference between that and long-lasting contaminants that can bioaccumulate in living organisms or in stream sediments, and particularly in slow-moving estuarine areas. So yeah, we understand all of that stuff. So if that gives you any comfort.
Thank you.
Yeah. So, any questions?
Not so much a question, but yes, just a comment. Following on from the Chair, in our role we need to kind of understand the existing environment as well. So some of our questions are inquisitive, just to kind of tease out perhaps existing perceptions and things like that. Just all builds the picture, I guess. And also just to note that we appreciate the importance of intangible values. The framework encourage us to think about tangible and intangible. So we're not just limited to physical.
Thank you.
Okay.
Yeah.
I have nothing further to add to those excellent comments from my colleagues.
Thank you so much. Thanks for your time.
Thank you.
Thank you. And so last I'd like to invite Dennis I think to speak to his evidence, but also close the case on behalf of the submitter group.
Great, thank you.
You guys are very lucky. It's New Zealand music, man.
That's right.
Oh, this place is here, eh? I heard I'm quite loud, so I don't really need a microphone. But anyway, I don't need this either.
You're on live stream.
Roaming one if you like. Get the roaming one if you like.
I think judging from the opening, you've got a pretty powerful voice, so I think you'd be fine without the microphone.
Need a reverb. Ko te waka, ko maunga tarana ki te maunga, ko ngongoro te awa, ko ngā toroni, me ngā ruhine, ngā iwi, ko okahu, me oro, ara kuku, ngā apu, ko Pareaka te Wairua, ko Dennis/Hoppy Broughton/John Kaui. Kia ora koutou. I'm also part of the trust as well and do a lot of planting with the whānau. But this is my love song. This is my love song to the Otokia. So I think by the time I finish this, you guys probably get the pronunciation down to a T. So, this is called Otokia. Sitting at your water's edge with my time, reflecting on memories of you and I. Everybody's watching you, no doubt in my mind, but nobody loves you the way I do. I said nobody loves you the way I do. Oh, Tokyo. Oh, Tokyo. Oh, Tokyo. Winter chills the summer breeze, love me. Velvet calling your name, it's love affair. Te kahu high in the sky, the tulips high, but nobody loves you the way they do. I said nobody loves you the way they do. Oh, Tokyo. Oh, Tokyo. Oh, Tokyo. Oh, Tokyo. Tokyo, baby, come and don't let it out. The doors are closed.
I don't know if you had any questions.
No
Not today.
questions. Thank you.
What is the creek called?
Otokia.
Yeah. That's the point behind the word. Pronounce it.
All right, well, thank you very much for that. That brings us to a close for the proceedings today, but just before we do wrap up, do my normal procedural question. Anything from the officers for us before we close for the day, and from the applicant, anything? All right, well, we reconvene on Monday. Some of you may be watching on Zoom. If you do, hope you enjoy it, and if not, enjoy your weekends. Thank you very much, everyone. We'll see you on Monday.
Thank you.